Simpson matter. Mr. Simpson is present before the court with his counsel, Mr. Douglas, Mr. Blazier, Mr. Neufeld, Mr. Scheck, people represented by Mr. Darden. Jury is not present. All right, counsel, the record should reflect that yesterday afternoon the court met informally with counsel here in the courtroom. And the court conducted an informal evidentiary proceeding concerning the exhibits that have been offered by the defense so that we could hopefully streamline our proceeding here this morning. All right, are both sides ready to proceed with their evidence lists? Mr. Darden?
Not exactly.
Okay.
As the court is aware, I have some objections to certain specific items. Mr. Goldberg and Mr.
What is it? It's
Clark.
Hertz and not exactly?
Well,
Yeah.
we need Mr. Goldberg and Mr. Clark for
Okay.
many of the others. I do have a handful, which I'm ready to discuss on the record.
Well, it would be more helpful to me if we could do these in order,
I would agree.
since I've got them all here and organized in numerical order.
We sent someone upstairs to arouse and get them down.
Well, we're late getting started already as it is.
I was here.
All right, and I noted this morning that the court had not been served with a copy of your writ. Is that an oversight?
I think it's being filed right now. That's me.
All right. Well, Mr. Darden, which of these are you prepared to go forward on? How about the first page? Can we at least get started on the first page? All right, let's start with the first page. Exhibit 1000 and 1001. My understanding, Mr. Douglas, is that has been, both of those are withdrawn by the defense, correct?
That's correct.
All right, there's an objection to 1003, which is a photograph of the defendant and his daughter at the reception. It's a 8x10 blow-up. Mr. Darden, my recollection is that you raised the objection to this.
That's correct, Your Honor.
What's your objection?
Same as before, Your Honor. This is a photograph in which the defendant is posing with his daughter. This photograph lacks any degree of trustworthiness or reliability. He is posing for a photographer. And so to suggest to the jury that this photograph is an accurate depiction of the defendant's demeanor throughout the evening of June 12, I would suggest is misleading. Will be misleading to the jury, so there's a 352 objection to that photograph.
Mr. Douglas?
Your Honor, I thought that the prosecution was making a foundational objection, as their papers to me suggested. Clearly, Denise Brown, Tia Gavin, Cato Kalin laid the proper foundation that that photograph fairly and accurately reflected a particular view at that time, what both were wearing. There was an added focus from that picture on Mr. Simpson's hand, confirming that there was no cut on his hand in that picture through Mr. Kalin. I think it is, in fact, admissible.
All right, I think there is an adequate foundation. Clearly, it's a photograph of a father with his daughter at a happy family occasion. I don't think anybody would take it as anything else, but it does have probative value as to the condition of Mr. Simpson's left hand, and it does have some relevance as to what he was wearing that evening. So the objection will be overruled. All right, number 1010.
Your Honor, may I have permission to plug in the video?
I'm sorry?
May I have permission?
You may. All right, record should reflect we've been rejoined by Mr. Goldberg. All right, next objection is 1010, which is Officer Risky's report.
Here's the objection to that.
All right, Mr. Douglas?
Your Honor, it was used at page 14195 of the transcript to impeach I'd also argue that it's a statement of a party offered against a party, and for those grounds, there's an exception to the hearsay rule.
Contrary to public opinion, the LAPD is not a party to this lawsuit, and it was used only for impeachment purposes. A small part of it, not in its entirety. Any portion of it that was used for impeachment was read into the record. It is in the record. Counsel can certainly argue that in front of the jury. It is hearsay.
I would also argue, Your Honor, that it has sufficient guarantees of trustworthiness, which is the catch-off exception to the hearsay rule, such since it was, in fact, a report. It could even arguably, although I don't think a proper foundation was made, but clearly there can be no argument that it is a business record. It was prepared at or near the time of the events by one who was charged with that duty for the purposes of accurately reflecting what he saw at that time. I think for all these grounds that under the catch-all exception at least, it would be admissible.
All right. I'll overrule the objection to the extent that it was used, a particular passage, and this was used, that portion that was actually used as a prior inconsistent statement to impeach Officer Risky will be allowed. The remainder, however, the objection is sustained. All right, 10:11, objection to this photograph, which is an outtake from a videotape from the, as I recall, what was it, American Journal?
Yes. Can I look at that photograph?
Sure.
Briefly?
And during the course of our discussions, either counsel may ask to approach to look at the exhibit itself. All right, Mr. Darden. All right. All right, number 1016, page from the LAPD manual.
Yes, I'm now arguing the exhibits that were admitted during witnesses that were examined by Ms. Clark, so I need to take a look.
Let me direct your attention to section 2346. This was a cross-examination of Detective Phillips regarding his obligations to notify the coroner. So the concentration should be on 2346, section 2346. It's about mid-page.
Objection to this document is hearsay, lack of foundation. It is subject to many different interpretations, as I recall from the testimony from the three homicide detectives in this case. It would be misleading.
I think, Your Honor, on transcript page 15011 to 12, Detective Phillips laid an adequate foundation for the introduction of this document. I think it was also used to impeach. It was also used as a business record. I think that all of those, and also, Your Honor, since it is a portion of the police manual, it certainly carries sufficient guarantees of trustworthiness so as to justify another grounds as an exception to the hearsay rule. For those reasons, I'd move for its admission.
All right. It will be admitted, however, only section 2346, excuse me, 238.46 will be admitted. The remainder will be redacted. All right, 1017.
Will the court do the redaction, the clerk, or should I do the redaction? Thank you.
Your exhibit.
Very well.
Mrs. Robertson has enough to do.
I agree.
All right, section 10250, Health and Safety Code.
Same ground. Page 15018 of the transcript.
All right, the objection will be overruled. However, the court will highlight section 10250 with a yellow highlighter, directing the juror's attention to the portion that is relevant, and I will draw an X through those sections that are not relevant to their consideration and save you the redaction problems. All right, that objection is overruled. All right, next item is Special Order 21. LAPD Special Order 21.
Same response, Your Honor, on pages 15018 of the transcript. An adequate foundation was laid. It was used to impeach. It certainly is relevant. I think it also qualifies for a business record, and it carries sufficient guarantees of trustworthiness.
I would disagree that it was used to impeach. I think the officers testified they were aware of their obligations.
All right, that objection will be overruled. All right, number 1019 and 1019A, this is the, my recollection, this is the tape-recorded conversation between Detective Heath and, Richard Heath and Detective Phillips.
Yes, Your Honor.
No, Mr. Willis, I'm sorry. Mr. Heath was the second phone call.
I think the transcript involved both conversations as well. If the court will recall, it reflected Mr. Detective Phillips' conversations with the coroner on the first call and also his delayed second call. I think it's very relevant. I think that Phillips was able to authenticate the actual conversation. It certainly goes to his state of mind. It certainly was used to impeach. I'm not sure of the court's practice in terms of which is the real evidence, if the document itself can go in or simply the tape. I'll leave that to the court's discretion.
Mr. Darden?
Consistent with case law, the transcript is not evidence. As for the tape recording itself, it is hearsay. Detective Phillips was here to testify to having placed a phone call to the coroner's office. I don't think it was used to impeach him at all. He told us what he said and what he did and why he did it, and he told us the time frame in which he did those things. This is hearsay, totally, completely hearsay.
All right, my recollection is that it was used as a prior inconsistent statement, so the objection will be overruled. All right, number 1021, statement of Detective Lang.
Your Honor, is the court allowing 19A as well?
Yes.
The transcript is what?
Transcript and the tape, but they have to be used together.
Sure.
Transcript isn't evidence.
Court has discretion to require the presence of a transcript of any tape recording.
There has been no attempt to make certain that the transcript is an accurate depiction or an accurate copy.
All right, but the court listened to the tape recording, had the transcript at the time it was played in court, and I make that finding now. All right, as to 1021.
Can I look at the document?
Your Honor, that document was used through Mr. Lang to impeach Detective Phillips. As the court will recall, there was the discussion of whether or not Lang had been informed that Mr. Simpson and his wife had been involved in past marital discord, whether or not Phillips had been told by Furman that Furman was aware of that discord and had been at the Simpson home on a prior occasion. Phillips had denied that ever occurring. We then used Lang's statement to impeach him.
And that was read into the record, and the witness was confronted with it, and that is in the record. The police report it's nevertheless hearsay, Your Honor.
I would appreciate the court's ruling that that portion that was used should be allowed, but the remainder redacted.
Okay, so are we going to have a blank page, and then at the bottom of the page?
I'm sorry?
Are we going to have a page, an 8.5 by 10 inch page, and then at the bottom of it, one section, and then we can just redact it? I think that's more than a little bit unfair. Any of the witness testifying to this judge in front of the jury. The police report is hearsay.
Given events, Your Honor, that have transpired since the introduction of that document, Mr. Furman's credibility is very important. Whether or not there has been some sort of code of silence is a relevant issue the defense has raised. The fact that Mr. Furman's partner chose not to recall or did not recall a very important aspect which we think led to an argument that there was a rush of judgment. The fact that another detective placed that in his report are all pieces of evidence that are central to the puzzle that we're attempting to create or to demonstrate the code of silence, the rush to judgment, the possibility that others would say things under oath even less than truthful to protect one of their own.
And that would,
Well,
counsel going to ask the jury to speculate to a number of things and paint all police officers with the same brush. And this is hearsay and it's prejudicial given the apparent intended use of the document.
I would say, Your Honor, all arguments that we're offering against the prosecution is prejudicial. That's not the test. The test is whether it is unduly prejudicial in light of the probative value. It's very probative that an officer wrote a report conflicting with the statement of another officer. It's very central to a case given things that have transpired since the introduction of this document.
all right, in the second full paragraph, there is a notation that Detective Phillips had advised Van Adder and Lang that Mr. Simpson and Nicole Brown Simpson had been embroiled in previous domestic violence situations, one of which resulted in Mr. Simpson's arrest. That was a statement that was inconsistent with the testimony here in court. Therefore, this second paragraph will be allowed. However, the hearsay objection to the remainder is sustained.
Did the court just read a complete paragraph or just a portion of the paragraph?
I'm going to leave in the complete second paragraph. Second paragraph states as follows: upon arrival at the crime scene, detectives were met by Detective 3 Ron Phillips, West LA Division Homicide Coordinator. Phillips stated that victim Brown was the ex-wife of O.J. Simpson, the well-known athlete actor. Additionally, Phillips stated that Mr. Simpson and victim 1 had been embroiled in previous domestic violence situations, one of these resulting in the arrest of Mr. Simpson. That's the only relevant portion on this document with regards to that testimony. The remainder will be redacted. All right, 1023, notes of Mark Furman.
Yes, sir.
Reference was made, Your Honor, on page 15123 and 24. I think they were used to impeach. I think it could be also qualify as a business exception. I believe Detective Furman also adequately authenticated the accuracy of that report. I think it reflects his state of mind. I think it also carries sufficient guarantees of trustworthiness to justify its admissibility.
I'm sorry, what's the hearsay objection to this? I mean, exception?
One, Your Honor, it's being offered to reflect not necessarily the truth of the matter asserted, but that certain things were said. It's being offered, Your Honor, to impeach. It's being offered to reflect the state of mind of the writer.
How does it reflect the state of mind?
Because it talks about those things that he observed that he thought were important at the time that he was walking through the crime scene. Also, Your Honor, being offered to establish his frame of mind in terms of what he knew and when he knew it, which we may then use to dispute some of the representations that were made at the time that perhaps there had been a gunshot wound to one of the victims, that there was some uncertainty, or whether there was certainty as to the nature of the actual crime. It's also going to be very important when we attempt to argue the significance of the picture that he is pointing to and what was in his mind at that time.
All right, this one I'll take under submission.
Sorry.
This one I'll take under submission. 1023. All right, 1027, which is, this is the freeze frame of Mr. Fung holding a paper bag coming out of the location where Mr. Goldman's body was located. Mr. Rokar appears in the photograph, as does Miss Mazzola and the two corners people. Mr. Darden, are you familiar with this one?
Yes, there's a 352 foundational objection,
I think the foundation is adequately laid by both Phillips. I think Fung was capable of laying the proper foundation. I think it is also self-authenticating.
Second. That's part of another video from
part of another video would be objecting to. Given the nature of the lens used to take that video, which as the court is aware that this telescopic lens tends to condense space and distorts space as well. It will be misleading to the jury. It will give the jury the impression that there are many, many individuals stomping over the crime scene in a very, very, very small area, which is not necessarily the case. As the court may recall, when you looked at that video, you couldn't tell if people were standing on the sidewalk or in the crime scene. It wasn't until we saw other videos that we could actually determine how far and how much distance there actually was between different individuals. It's misleading.
I think the prosecution went through great pains to call other witnesses to attempt to rebut any suggestion that there are a lot of people stomping through the scene. The picture speaks for itself. The arguments of counsel go more to weight than to admissibility. It is in fact self-authenticating. It is not unduly misleading. I think that both sides would be capable to draw whatever conclusions they deem appropriate from the pictures, but certainly given the other testimony of other witnesses, Mr. Darden's concerns are not well taken.
They have never called a witness to explain to this jury the problems with space and distance in this video and in this photograph, Judge. So there's no evidence before the jury that will help them determine what the actual distances are between different objects and different individuals.
If I'm not mistaken, they called the photographer themselves, Your Honor, who took the video from which this was drawn to talk about where he was, how he did it, whatever distortion questions there may have been. So the jury is fully apprised of those concerns.
All right, but the issue that is depicted in this particular photograph, though, is Mr. Fung coming out of the area where Mr. Goldman's body was holding the paper bag. That was the issue, and that's what it depicts. So the objection will be overruled. All right, 1029. This is the two-page fingerprint report.
Can I see that, please?
I believe that's in through Aguilar.
Later.
Correct.
It may have been. My recollection is towards the end when we got to Mr. Aguilar. We went through that again.
Correct.
It may be also 1323.
It is, in fact, 1323. I'd like to keep two different documents together in sequence.
All right, we'll take this one as submission. My inclination is to sustain the objection to this, since it appears also to appear as Defense Exhibit 1323, for which there was no objection.
We'll compare the first round.
So remind me to come back to that one. All right, 1030.
Another document, Your Honor, that was authenticated by Mr. Aguilar. Can I just see that?
All right, let's do this. We have two sets of these fingerprint documents. Let's compare those and see which one is which, so we'll take those up. Mrs. Robertson, remind us to look back at the fingerprint documents. All right, 1031, coroner document. Objection is foundation. Mr. Douglas.
Submitted, Your Honor.
All right, objection sustained. All right, 1036, photograph. Where does this appear in the transcript?
Your Honor, at page 15886 and 87.
And what was the testimony relevant to this?
It focused on the issue of contamination, whether in fact that appeared to be Mr. Goldman's body, whether in fact there appeared to be a glove on the body. It was very central at that time to issues that we were raising as to the integrity of the crime scene, and to show the apparent lax manner in which some of the crime scene and the victims and the bodies and the evidence were handled.
There was no testimony to establish whose gloves they were, how they got on there. This was a photograph that pertained to the point in time when Ratcliffe and Jacoba were taking care of the bodies, and Mr. Goldman's body was on a sheet, and there was a pair of plastic gloves on his body. Whether or not that actually proved any contamination or transfer from one body to another was never established or never linked up with any of the appropriate witnesses.
Well, I think the jury was able to glean from the evidence, Your Honor, that even the prosecution's theory is not that those gloves were left by the killer in the case. Those were gloves that were consistent with the kinds of gloves that we've seen in court, that were worn by the criminalists. They are there on the body after the body has been moved, if I'm not mistaken. The body's on the walkway. Therefore, it's clear, or at least we must give some belief that the jury can extrapolate, that those gloves were placed there by some police official. The fact that no one knows how they were there or would want to own up to why they were there is not surprising.
Well, Your Honor, if somebody would own up, if the defense had decided to call those witnesses that would have been appropriate for that foundation, they never did. And they're asking the jury to speculate that something improper was done without having ever called the witness to establish that something improper was done.
Which photo did this come from?
It's a photograph turned over to us by the prosecution, Your Honor.
It appears to be one of Mr. Rokar's photographs and appears to have a frame stamp on it of 194.
I mean, Your Honor, I don't think that a foundation necessitates us proving whose plastic gloves are shown on Mr. Goldman's body when it's laying on the pavement. I think that the foundation that's necessary for the admissibility of that photograph is that this was a photograph on June 13th, fairly and accurately reflecting the body as it was at some point in time.
All right, what was the page in the transcript?
15886 and 87.
All right, I'll take a look at that.
What volume was that?
I have page numbers, I don't have volumes.
Okay, next one is report of Officer Vasquez, 1042.
Submit it, Your Honor.
I'm sorry?
Submit it.
All right, objection sustained. All right, 1043 is a videotape of the Bundy crime scene. Which videotape is this?
Is this the video done by
We gotta have
some TV station?
that narrows it down.
Well, no, actually, It's narrow enough for me. Because I remember.
If we can see 1043A, B, or C, which are clips from that video.
Yeah, that'll tell us which one it is. All right, Ms. Clark, are you familiar with these?
Yes, can I see you around? Thank you.
And Mr. Douglas and Mr. Goldberg, you were part of our conversation yesterday about these videotapes as well. How do we propose to redact these to the portions that were used?
Mr. Harris is currently doing that as we speak, Your Honor. Since he's been present during the play of all of our videos, he's familiar with those scenes that have been played. We will then show them to Mr. Goldberg or whomever upon our conclusion of that tack. As the court will recall, by the way, Your Honor, this was the video where there was a preliminary objection because we didn't know who the photographer was. There was then a 402 hearing with Lang. There were strenuous objections at those times. We had the hearing. Lang laid the foundation. The court overruled the objection, and it was then played for the jury. But attempts had been made much earlier in the trial for this snippet, and then we were able at that point to lay the adequate foundation.
Your Honor, if it's helpful.
The objection on this is not foundation. The objection is 352, Your Honor. And the problem that was presented, and I think actually the court's in a better position to assess why it's 352 now than it could have been before, having seen all that it has of the actual photographs and of all of the testimony at the crime scene, of the people at the crime scene, and of the testimony of the photographer, videographer that the people called to put the American Journal photograph into perspective, which is this, that this video was actually taken by someone across the street. All of the photographers, according to that testimony, were across the street. They were not allowed to be anywhere near the crime scene. As a result, they had to use a zoom lens. In the use of the zoom, you have a compression of space, making it appear that everybody's on top of each other, crawling all over each other. That's the problem with this video. It's very misleading and confusing, highly prejudicial to the accurate depiction of what was going on at the crime scene and the manner in which it was handled. The stills are actually much better because there isn't nearly as much misleading information. And I think that if the court were to admit the stills to show what they want to show is how were mistakes made in the handling of the crime scene. For example, Rokar looking in the mailbox, someone holding a coffee cup, and Dennis Fung stepping out of the crime scene with a brown bag in his hand and not wearing any gloves. That indicates everything the defense needs in terms of being able to communicate to the jury what mistakes were made in handling the crime scene. Fair enough. And the people would withdraw their objection to 1043A, B, and C. But I think that the video is unduly misleading and confusing because of the manner in which it was shot, and I think that that would be unfair.
All right. Then the people withdraw their objection to 1043A, B, and C. What I will do is ask Mr. Harris to exhibit to me later today 1043, the portion that was shown.
Can I say one thing, Your Honor?
Certainly.
Your Honor, one, these videos were all taken across the street. Those that the defense seeks to introduce, those that the people have already introduced. Two, there was, and I forgot his name now, the African-American gentleman with the balding head who testified because he had been hired as a stringer to take photographs on this day, and there was a major quality of evidence focusing on that very issue. In fact, responding to Ms. Clark's concerns that there was this element of distortion. Therefore, the arguments that she's made, which parrot those made earlier, simply go to the weight to be given, not to the admissibility of the tape.
But, Mr. Douglas, all I'm saying is, gee, before I finally decide, I'd like to see it one more time.
Very well, Your Honor.
All right.
Your Honor, just for your assistance, I've identified at page 17904.
I'm sorry, Mr. Sheriff, I can't hear you.
At page 17904 of the transcript, when the discussion of this begins,
All right.
at least for these segments, the court read out the counter numbers, because these were videotapes that had counter numbers, so I think you'd be able to recreate.
All right. All right, the record reflect that exhibits 1044A, 1044, 1044A, 1045, 1046, 1046A have been withdrawn by the defense.
Correct, Your Honor. They all concern the testimony of Rosa Lopez.
All right, also 1048 has been withdrawn.
Correct, Your Honor. That was used only to refresh.
Right, all right, 1052. Hearsay objection.
Your Honor, that was discussed on transcript page 17998 through 18001 concerning an entire area of cross-examination of Detective Lang as to the importance of having a body examined soon. It was used to impeach. It is used as offered as an exception to the hearsay rule.
I need to see it again, Your Honor, but it was my, oh, thank you.
I'm sorry, what was the page reference?
17998 through 18001.
Thank you.
People had no objection to the pages 29 through 38. People object, however, to the last two pages or three pages offered concerning stomach contents for which Detective Lang could not have been impeached. It would be inappropriate, improper impeachment of him. That's beyond his field of expertise. It has to do with assessment of time of death for stomach contents.
Mr. Douglas, that's probably because that portion was not used with
Your Honor,
Detective Lang.
I don't want to argue its admission.
I'm sorry?
I don't want to argue if its admission if it wasn't used. So
All right. To the extent it was not used.
to the extent it wasn't used, that's fine.
All right. All right, then what we will do is
Well,
sustain the objection to the portion that was not used.
Well, the people would urge the court to sustain the objection even if the portion was used for stomach contents because it would be improper impeachment because it's beyond the witness's field of expertise.
Mr. Douglas just acquiesced to that.
I heard him only acquiesce to the part that was not used. I can't remember if it was used with
No,
Detective Lang.
we've agreed that it's just the physical observations made by the investigating officer at the crime scene has nothing to do with autopsy examination or anything like that.
Well, the part about autopsy examination and time of death begins on page 30, in which case it should be the only thing that's really relevant to Detective Lang is the first page, 29.
Can I see it then?
Yeah.
willing to agree to the redaction of the bottom quarter of page 38, beginning at examination of stomach contents, and the page 40 and 41, which would be 39 rather, the bottom of 39 and through page 41, because I don't think that those were used. To the extent that other sections were used to impeach, I would stand on the court's wisdom after reviewing the transcripts.
How do you impeach a detective with the examination of bodies to determine time of death?
I don't recall specifically what was done, so as I say, I'm not willing to concede that at this point.
All right, I'll look at 17,998. All right, but we do accept the concession to remove those last two pages.
Yes, Your Honor.
All right, 1053.
I think that's self-authenticating, Your Honor. There was a foundation objection. Since she's been called as a witness, there can be no real sincere challenge to the accuracy of the photograph.
Submitted? All right. Objections withdrawn. Okay, 1055, my favorite objection. Maglite. Ms. Clark.
For the record, Your Honor, 1054 was withdrawn.
Yes, I'm sorry, thank you. 1054 is withdrawn. Ms. Clark.
Flashlight used. I can't even remember. Was it
Maglite.
Maglite? Oh, withdrawn.
Okay.
What was Could I see 1054?
1054 was that one-page fax from Mr. Coleman.
We withdrew.
Mr. Coleman?
It's been withdrawn with regard to Furman.
Oh, okay. Thank you. Okay.
Ring a bell? Okay.
Yeah.
The Mr. Darden indicated yesterday he did not know if there was an objection to 1062, 63, 64, and 65, and he wanted the ability to re-inspect those items.
Right.
And they are available. Two of the items are here right now.
Clearly. Now, Your Honor.
Is
Be
the
my
golf bag
guest.
out?
I'm sorry?
Is the golf bag there? Golf bag, is that out there?
I don't think we brought the golf bag up.
I'll get somebody down to search him. while you're
Mrs.
on the
Robertson
bench.
said, where is it? It's in the closet.
Oh, that's fine. We could,
We'll
All
get
right,
some-
how about at a recess, we'll do that. All right.
For the record, the golf bag has been inventoried by the court's clerk at least twice, if I'm not mistaken.
As well as by the bailiff.
Correct.
All right. All right, 1066 has been withdrawn.
Correct, Your Honor.
All right, 1071. Crime Scene Field Unit Protocol and Procedures Manual. Ms. Clark.
I think this is Mr. Goldberg, right?
I'm sorry.
Yes, this was the, good morning, Your Honor.
Good morning, Mr. Goldberg.
This is the black binder that contains the draft manual of the Los Angeles Police Department. I don't think it was recognized by Dennis Fung or Andrea Mazzola, but Greg Matheson and Michelle Kessler both testified that they did not recognize all the documents in there. They had not reviewed the entire manual. However, it was a draft manual, and I think both of them stated that there were certain things in the manual they disagreed with. So there is no authentication for it, and there is no exception to the hearsay rule.
Well, there's authentication for what it is.
Right.
Well, yeah, but I mean, the documents within it, they can't actually go through it and say that they recognize all of the documents within it even.
Matheson said that he put it together.
No.
No. Matheson testified that this was a manual that he was putting together for purposes of accreditation. I mean, the testimony, I think, is pretty clear from the witnesses. Some of them are handouts that some of them recognized, some weren't. Michelle Kessler said that she reviewed all of them. Some she agreed with, some she didn't necessarily agree with, but hadn't finished the process of finalizing it. I mean, it is what it is.
Actually, it was the supervisor of the trace unit, as counsel will recall, that was in the process of putting it together, and he stopped when that supervisor either left or was transferred. There was some testimony to that effect. Mr. Matheson was never personally putting this together, if that's what counsel's suggesting. I don't know if he is. But at any rate, the point is, to me, this isn't even arguable. There is no exception to the hearsay rule under which something that's not in effect comes in, and to which every page has, or every handout has not been authenticated.
The issue is, what is it being used for? I think that the issue in the case is they're running a lab with either without a manual or with a quasi-manual. Now, as we go through the list of these objections, there are certain...
Quasi-manual.
I'm sorry?
Never mind.
All right, yes. We're not... The fact that they have such a manual, and at various different points as we go through these objections, certain parts of this were used and I think are not objected to. Certain parts of it, I think everything that was used is not objected to. I may be wrong. Are there some others here that...
I thought there was only one, only one particular document, or two particular documents that I can recall being used from that. One was the protocol on how to collect blood, which we objected to. It was marked several times as a number of different exhibits. And the other one was an ancient memo from Chief Gates that I believe Michelle Kessler was asked about, and Mr. Garden also objected to that, or will object to that.
There's also a section on forensic photography on how to take pictures that was shown to some of the witnesses, and Mr. Regal testified about that. So it was used, to that extent, it was used for impeachment at various different times. I'm not... I don't understand. If the objection is that that is not what it purports to be, then I just don't think it's well taken.
All right. Court will sustain the objection under 352 because it is a draft manual and of little probative value.
If I understand, we can, of course, make references to the fact that they were shown this manual and they were impeached with it. You're not ruling out reference to the manual by any means as it appears in the transcript.
Not to their testimony, no.
No, the only thing
But
is
the
that
item
we
itself.
can't pull the manual out and start showing the jury pages that weren't shown to the witnesses.
But if you're smart in your argument, you won't get down to quibbling about the manual, will you?
Well, I think it's of some relevance that we have a crime lab that doesn't have a manual.
Your Honor, we're not making a motion to
I've never
strike
heard of
that
a crime
testimony,
lab
so
like
there's
that.
no point of arguing about it.
Until I got here.
Because if you think quibbling about lines in the manual is going to persuade this jury one way or the other. All right, 1082.
Excuse me, Your
Oh,
Honor.
I'm sorry, 1078 is the next objection. This is the videotape of glove on a blanket.
Yeah, this was the famous blob that was on the blanket that we had extensive arguments about previously. I renew those arguments here. I don't care to restate them because I know that the court heard them at length previously. In addition to that, Your Honors, as we previously discussed yesterday, we were objecting to all of the videotapes conditionally upon redaction, and that would pertain to this as well, but I think we have basically agreed to that, the
All right.
procedure for handling that objection.
All right, the objection then is overruled, subject to the redaction of the portion that was used on that one. 1082, the objection is, any argument on that?
No, Your Honor.
All right, the objection is overruled subject to the redaction of, to the portion that was used. 1083,
It's no argument, Your Honor, the same.
all right. Objection will be overruled subject to the redaction to the point, to the portion that was used. All right, 1084,
Your Honor, this was the evidence collection sheet that I referred to previously in the last argument that I made. This particular one was shown to Dennis Fung. As I said, it was marked a couple of times. And Mr. Fung testified, let me get the page citation. I don't have personal knowledge of this, but I was told that Mr. Douglas indicated that there was no foundation for this and they might be withdrawing this.
I can clear this up if you want, Your Honor. The 1084 is the 3-page handout dealing with how to collect a blood stain. It is also 1118. It was shown to Ms. Mazzola, and then it was even shown later to Michelle Kessler. See if I can get that reference. And that would be 1319. Now, when Dennis Fung was shown this, he, of course, couldn't remember seeing it before. When Ms. Mazzola was shown this, and this is at page 24396 at the transcript, she acknowledged that this was what she was given at the SID Mini Academy, that she was familiar with it as the handout on how to collect a blood stain. I would note that this is the same 3-page document that we were given by Fung and Mazzola at the split hearing on how to collect the blood stain. I'm fairly astonished that they can come in here and object to this on lack of authentication. It's just an absurdity. And then on 1319, that's the same exhibit, which is at page 42003 of the transcript. Kessler acknowledges this, and
Which page did you say?
I think it's I'll check it for you, 42003 of the transcript. It comes up again, but I think it's admissible simply on the basis of Mazzola's testimony that, yes, she was familiar with this as the document that they handed out at the SID Mini Academy on how to collect a blood stain. It was up on the Elmo. It was the jury's seen it. And I suppose that for the sake of clarity, we could cross-reference them.
Well, Your Honor, these issues are really very simple. First of all, counsel's right. Mr. Fung did say that he hadn't seen it, so there's no authentication there. I'm not positive about Ms. Mazzola because I hadn't recalled her, haven't been asked about it. And Ms. Kessler was only asked one question about this document and nothing as to whether it's a current policy. I mean, no authenticating type questions as to what it constitutes specifically. And I'm also looking at 42002. But there's a very simple way of resolving these issues, and that is that there's something called the hearsay rule, and we don't allow hearsay into court unless it qualifies under some exception. We do have exceptions for materials of this kind when you are cross-examining an expert witness under 1071, as I recall. We've argued this numerous times in the past, if they've read, relied, or considered this type of material. And then you don't get to introduce the underlying report, even then. Even if the witness says, yes, I recognize this and I relied on it, you simply get to ask them questions about it because the underlying report is still hearsay. It is simply coming in under this evidence code provision for the purposes of testing the opinion and the underlying basis for the opinion of the witness. So you can cross-examine them on it, but you don't introduce the underlying document. So I don't see any hearsay rule exception to allow this in, any authentication for it under any one of those hearsay exceptions that they read, relied, or considered it. And at any rate, even if they were cross-examined on it, which they weren't, as to things in the pages that were inconsistent with what they did or whatever, which is not the case. But even if they had been cross-examined, the cross-examination would stand, but the underlying document itself would not come in.
Your Honor, at page 24396 of the transcript, question to Ms. Mazzola. This is in regard to 11-1118. Show you this, ask you to take a look at it. Item number 13, okay. Question by Muelas, I'll also look at that. Do these pages represent a handout you received at the SID Mini Academy? Yes, they look familiar. And in that handout, it goes on to discuss how they should collect the blood stain. There was extensive cross-examination about how you're supposed to collect the whole thing, particularly for purposes of RFLP analysis. This is the handout that they gave us on how they collect blood stains, which Mazzola authenticates and Kessler suggested and Fung forgot about. But there's no question as to what it is. It's not a hearsay problem here. This is their instructions on how to collect a blood stain. It's relevant for many different points. A, we impeach them on the fact that they didn't follow the procedure. Because if they followed the procedure, then they should have removed all the blood from the Bronco.
So if it's so simple, what's the evidence code exception for this document?
No, I'm saying that it's offered for impeachment. It is also a business record of the SID laboratory with respect to how to collect the blood stain that was given out to the criminalist as a record that she's supposed to follow. So in that respect, it's not even hearsay. It's being offered, well, it's a business record. It's being offered as a set of instructions on how they're supposed to go about collecting blood stains. It's offered for impeachment with respect to the techniques involved. And in contrast to other techniques, it also comes in as a document that's reasonably relied upon by experts in the field. These are their experts. These are the procedures that Mazzola at least acknowledged she's supposed to follow in the collection of blood evidence. So it comes in under as a basis for her expert opinion as to how you're supposed to collect blood stains at a crime scene. So there's a number of different grounds to admit it. And I'm very surprised that they could object on authentication grounds, given the testimony in the record and the fact that they turned this over to us at a split hearing and in discovery as their methods for how to collect the blood stain.
All right, objections overruled. All right, 1095.
This was it's just simply a list of things that's supposed to be in the truck.
Yes.
And no one ever authenticated having seen it, and it doesn't have any relevance. It doesn't qualify under any hearsay exception. I'm not even sure the theory under which it's being offered.
Mr. Scheck?
The only problem here is with respect to the actual testimony. Mr. Fung said that he couldn't specifically recall seeing this form before, but he'd seen one like it with respect to what items are supposed to be in the crime scene truck. And this is the only document that they ever turned over to us as to the list of things that are supposed to be in the crime scene truck.
All right. The objection sustained. That was 1095. All right, 1101, 02, 03, and 04.
Those were the same objections that I previously made to the videos, Your Honor.
All right, those objections will be overruled, subject to the redaction of the portions that were actually displayed to the jury. All right, 1106 has been withdrawn. All right, 1115.
Is that the Gates?
No, it's just a one-page, starts with a quote from Ralph Waldo Emerson. All right, withdrawn. 116.
116.
I'm sorry, 1116. That was 1115 that was withdrawn.
I'm not, 1116 is another one of the handouts to the field procedure, from the field procedures manual, as I recall. And we objected to that on hearsay, no authentication, and irrelevant grounds. I just want to check the transcript to... Mr. Bluthal can be heard, and maybe I'll just respond to that.
Your Honor, this has to do with what they're supposed to do with respect to photographs at the crime scene. And just like 1118, Ms. Mazzola did testify that they did receive a handout on forensic photography. She couldn't be sure that this was exactly the same one, but she did remember a two-page handout on forensic photography, and it certainly could be the same one. And for all the same reasons that Mr. Scheck already articulated for item 1118, I think they apply here with equal force. There's no difference other than the fact that she's not quite as absolutely certain. Short of that, I think the same degree of authentication has been established, and thus the foundation has been laid. 1 second. No, but if their objection is authentication, okay, I'm limiting myself to the authentication argument because obviously all the other arguments in terms of impeachment and a business record, all the arguments that Mr. Scheck already made would apply with equal force here, so there's no reason to restate them. So I'm assuming that their objection is limited to authentication. But on this document, unlike 1115, where we withdrew it because we agreed there was not sufficient authentication by the witness, here again there is the authentication by Ms. Mazzola.
The alleged authentication that counsel refers to on page 24-249 of the transcript, starting at line 11, is by Mr. Neufeld. Show you what has been marked as defendants 1116. Ask you to take a look at those 2 pages. Ms. Mazzola's 1116, defense 1116, the handout that you received on forensic photography. Answer, I don't know if it is the exact handout that we received. Question, could be. Answer, it's possible. I mean, that's the skimpiest authentication I think I've ever seen in a very long time.
The next 2 sentences, though, Your Honor, are...
You
said it could be...
Well, that she does... Counsel,
well, you say you recall, however, you say you recall receiving a handout on forensic photography. Did you not answer yes? So that is the only handout.
Excuse me, counsel.
Sorry.
My recollection is Mr. Goldberg was addressing that.
So she received some handout, and she says it's possible that it could be this one. That just doesn't even come anywhere arguably close to being authentication. But also, I'd renew and restate the objections that I previously had. I mean, unless there's something inconsistent about this, or they've been cross-examined about it, yeah, possibly that cross-examination is admissible under 1070, one of the evidence code.
All right.
But this should not be allowed.
No, the only point is that we received a group of handouts from the prosecution. This is the only handout on forensic photography. There isn't any other handout. If they were suggesting that there was another one, then I could understand that perhaps the authentication might not be adequate here. But if there's only one, and she said she did receive one, and this could be it, that should be adequate.
All right. The objection will be sustained on 2 grounds. 1, authentication, and 2, Mazzola wasn't the photographer. If you had asked these questions of Mr. Rokar, that would have been different. All right, number 1117. This is the prosecution videotape of the evidence collection demonstration.
Yes, Your Honor, we simply objected to the sound on that and asked that be redacted out pursuant to the court's previous rulings.
All right, then the objection is overruled, subject to the sound not being played during the course of if the jury wishes to see this video again. All right, 1118 we've already discussed. 1120. Is the report of a statement by Andrea Mazzola.
Yes, Your Honor, this was actually the subject of a previous court ruling where counsel wanted to cross-examine Ms. Mazzola about a interview that she had with DA investigators where they were asking her about a treatment for a book or a screenplay that someone had written to the effect that evidence had been planted. I don't know whether the court recalls that. It came up during Ms. Mazzola's testimony, and the court ruled that the court would not allow cross-examination on that subject matter. There was very limited cross-examination as to there being an interview and limited cross-examination, as I recall, as to whether or not she said something or other about the blood vial, and then she was shown this document and said she'd never seen it before, didn't recognize it. There's no authentication for it. There's no foundation for it. It's hearsay, and it should also be excluded under the court's previous rulings on this issue.
All right, objection sustained. All right, 1121.
That was the 1118 that we just discussed, I'm sorry. Yeah, I will
1121. What's the objection to 1121?
I didn't know, I didn't think it was objected to 1121.
All right. Then objection will be overruled to 1121. That's what I have for my notes from yesterday. All right, 1122, 1123. Mr. Goldberg, if you recollect, these are Elmo printouts.
Correct, and Mr. Douglas agreed that the prosecution could substitute original photographs for those. Correct, Your Honor.
All right. That'll be the order. Madam Reporter, we'll take a break in about 5 minutes. All right, 1132. Board. Mrs. Robertson, 1132.
Your Honor,
Mr. Goldberg.
this is a board that Greg Matheson was shown, and the discussion starts on page 25679 of the transcript. What it was intended to show was that 20 nanograms of DNA would be at the size of a pin, and that 2 nanograms would be invisible. Mr. Matheson never agreed with that proposition, although he was shown this diagram. And what he did say that makes it a little bit more confusing is that 20 nanograms of DNA contained in blood cells, in other words, if the DNA had not been extracted out, is visible. And I think he may have even said that 2 nanograms of DNA in blood cells is visible. And what this is trying to indicate is the visibility of 20 nanograms and 2 nanograms of DNA outside of red blood, with the idea that it would be easily contaminated because you can't see it. But this is a proposition to which he did not agree.
What is your page site?
My page site is that the discussion on this issue starts on 25/6/79.
All right.
And there's a particular discussion on 25/6/80, lines 2 through 16 that I highlighted as to what 20 nanograms looks like, et cetera.
Mr. Blazier?
Well, Dr. Cotton was also asked about this chart and testified at 27112. It was used in a hypothetical about the amounts of DNA as indicated on the chart, hypothetically, if that had been injected or contaminated into the Bundy drops that had been degraded, that would give a positive RFLP result. So I think it's been authenticated through Dr. Cotton.
All right. I'll take that one under submission.
And
All
perhaps
right.
the court could read it would get the gist of the people's objection if the court read 25/6/80, the citation of previously.
All right. Let's see 1133, PCR amplification board. Mr. Goldberg.
Your Honor, this board and the next one were used also with Greg Matheson. And virtually what happened is they simply put the board up there and asked Mr. Matheson almost no questions about it whatsoever. They did ask Mr. Matheson that whether PCR amplification involved 32 cycles, which he agreed to. But as to the number that you end up with, the 4,290,000, he never agreed to that number. All he said is it would be a large number. So there is no authentication for this exhibit.
Looks like 4 billion to me.
Excuse me? Yes, right. Ms. Deidre was blocking off 3 of those zeros over there. But at any rate, the discussion for that, Your Honor, commences on page 25/685. And the most relevant portion is on 25/687, where he is asked, and typically that is done 32 times correct. That is the protocol forensics yes question. And that chart depicts that starting out with a very small amount and doubling it 30 times, I guess that's a mistake, leads to a very large amount correct. Answer, double it 32, yes. It's an extremely large number. But there's no statement as to the specific number.
Well, I'm not sure if this is a new objection. This was objected to at the time on page 25688, and that objection was overruled by the court. But more importantly, Gary Sims testified about this chart specifically on, and I'll refer the court to pages 28416 and 28425, where he talked about this chart and this chart, and authenticated that the concept that we were portraying there is accurate. And I'm not sure if they're suggesting that there's some sort of mathematical problem. They didn't bring that up, and I don't think there is.
All right, the objection's overruled. All right, number 1140, 3-page analyze evidence report. This will be the last matter we'll take up before we take a break. Certainly.
Could we see that one, I think?
Yeah, this is Mr. Matheson's,
Well, we also objected to 1134, Your Honor, which is the,
I know,
what?
objection's overruled.
If I could see 1140, I think we can.
I thought we were just discussing 1133.
We were discussing both of them. you want to be heard on 1134?
Maybe the court had already ruled on that. I don't know.
If you feel you need to say something specifically with regard, because it's the same mathematical process that it
No, I
depicts.
thought that the 1134, as I recall, shows a number of different overlying triangular
Yes.
patterns. And I don't know whether that was used with Gary Sims or not, Your Honor. But at any rate, on this particular one, this one was put up simultaneously to Greg Mathison's testimony, but they didn't ask him any questions about it. He wasn't asked, what does this show, or do you agree with it, or, I mean, there was nothing in the way of authentication.
Mr. Blazier?
It was just simultaneously shown to his testimony.
He authenticated this at 25688 without objection from the prosecution in terms of the concept that's being displayed here about when you amplify DNA, different types are going to get amplified as well, and Gary Sims talked about this extensively.
We see the kind of loose language that's being used. You've authenticated the concept here. The discussion of this starts on page 42049, and it was shown. Oh, I'm sorry. It starts on 25688, and it was put up there, but there were no questions about it.
No, he was asked questions about, isn't it accurate that if you've got several different components of a mixture and the amplification is done, they all get amplified and you wind up with a lot of each one of them. And this is just 4 times what's on the last chart.
I mean, I just think there's to be some authentication for the correctness of these numbers. And to my knowledge, no one has said these numbers are correct. I mean, maybe they are. I don't know. I have no idea. But I don't think there's anything in the record
Gary's,
that the numbers are correct.
yes.
All right. Objections overruled. All right, 1140.
1140, I think the
I'm
problem...
sorry, I didn't hear the court's rule.
Overruled.
1140, I think the problem there was the second page was the court redacted parts of that. And
Well, this same document was marked by the prosecution and may have been redacted in a different way. But for some reason, counsel's cut out the results on 117, 118A, and 118B.
well, that was
I don't know why.
that was because the court would not allow them to go into the 117 after that. I can't remember the exact reason, but it was because they had not raised it in their direct, I believe. And they were trying to make an argument after they were done.
But as I recall, what happened was Mr. Sims then testified based upon Mr. Mathison's report what the conventional serology results were on the rear gate stains for the purposes showing that there was degradation.
So you have
on
no
those
objection
stains.
to the complete report, is that what you're saying? Which is already a prosecution exhibit?
Yes.
All right, then what we'll do is withdraw, since the complete report is, do you know, can you give me the cross-reference number on that?
I can't do it right now, Your Honor. but
All right,
we'll find it.
then what I propose then is that we withdraw the defense exhibit, since it is a redacted copy, and substitute in its place the complete copy. Any objection to that?
Yeah, the only problem with that is I think the prosecution's exhibit is missing that page. That's my recollection as to why I introduced...
All right, well, since we both agree that we need the complete report, we'll get the complete report, we'll substitute it in both locations. How's that?
That's fine.
Okay, we'll do that. Okay, let's take a 15-minute recess, and we'll resume with 11:43. All right, back on the record. 11:43.
Your Honor, this was the series of printouts that were to portray the EAP issue, where the prosecution said that yesterday we didn't have any objection, other than those we previously argued at the time, other than that the resolution on some of these is poor. The actual photographs are all in evidence anyway. And maybe if there's some sort of admonition or some way of letting the jurors know that they can take a look at the actual photographs from the EAP runs, where the resolution is significantly different, materially different than on the Elmo.
Well, these weren't put on the Elmo, these are PowerPoint slides.
Yep.
I have no objection to them being told that there are pictures of these if they need to look at them. I would object to them being told that the pictures are much better than the slides. I mean, the slides are there to illustrate where the bands are and in their relative positions, and they do that quite well.
All right, but they have available to them, what is available to them, though, is pretty clear to my eye.
Yeah.
So, all right. And then that objection will be overruled. All right, number 1145.
Good morning, Your Honor.
Mr. Clark, how are you?
Just fine, thank you. The court may recall there was a substantial argument over this exhibit, and the court sustained objections on multiple grounds.
Many times.
Yes. That is also Exhibit 1205, by the way. It is indeed the same exhibit.
All right. All right. Objection sustained. 1154.
Objection to that item, and that again was used with multiple witnesses, is hearsay and no foundation. This was a letter from CACLD to Cellmark. And the court sustained those objections at the time as
Didn't
well.
Dr. Cotton, though, testify to this at some point?
Actually,
All right, so let me just get the basis for the objection.
Hearsay and no foundation.
Your Honor, if you look at the transcript, initially they objected not to on the foundation hearsay grounds, and the court ruled that my questionings for the foundation were inadequate. And then you called me over to a sidebar and you instructed me on how to complete the foundation. I came back, I completed the foundation using questions that the court suggested. Mr. Clark again objected, and you overruled the objection, and you at that point let it in. If you look at page, beginning at, looks like it's 257, oh, I'm sorry, 27502, 275. 27501. In fact, the 27502, he again renews the objection after I laid the additional foundation that the court suggested, and that's when you overruled the objection and allowed me to publish the exhibit.
All right. Is the matter submitted?
Yes.
All right, objection's overruled. All right, 1158 is being withdrawn.
For purposes of clarification, that is the same as 1191B. If that's going to be offered by the defense, then we have no intention of moving in 1158, but I think we need to clarify that.
Is the DQ alpha types of fungal Mazzola? Is that what we're talking about?
Yes. Actually, and polymarker as well.
We'll stand outside the presence of the jury, but we'll move it in by stipulation if you want, that's no problem.
1191A and B are coming in, then the withdrawal of 1158 is adequate.
Okay.
I don't know about 1191 yet.
All right, 1170.
Your Honor, how are you?
Mr. Harmon, how are you?
Fine, thank you.
Still got the beard.
Just taking after other bearded gentlemen around here. Every objection was sustained to that. which there was no testimony about that. Mr. Sims expressed no expertise in it. You agreed that it was beyond the scope of the testimony. And so while they succeeded in getting it marked, that was the extent of it, Your Honor.
This is what, 2-8, this is...
1170?
1170.
That's Cellmark's polymarker strip.
Cellmark's polymarker on the steering wheel. Mr. Sims looked at it, said he was familiar with it, but said he would not venture an opinion on it. It, however, is the same, the underlying polymarker that was used for the results on the steering wheel that was introduced through Robin Cotton. I mean, this is the polymarker strip that they used. So I don't
Is it in
understand how
evidence?
he's objecting on lack of authentication.
Is it in evidence someplace else, under a different...
Well, Mr.
Can I answer that, Your Honor?
Mr. Clark did not offer the strip itself. He offered the results on their results board based on their underlying data. So if they're saying there's no authentication for this, I don't see how they got half the evidence in this case in the first place. I don't understand how he can sit up here and object to the polymarker strip that they gave us that's the basis of one of their results.
Well, the problem is we've got an exhibit, and the testimony about the exhibit indicates an inadequate foundation.
That's not accurate. What it states is that he says he is familiar with this as the polymarker strip from the steering wheel. He then goes on to say that he does not want to draw any judgments from it because he doesn't feel sufficiently familiar or expert with the polymarker. That's different from saying it shouldn't come into evidence. I mean, he's objecting on lack of authentication to a result he put in. I mean, this is frivolous.
To answer the question you asked him that he never answered, the strips are not in evidence. They were never shown to anybody in front of this jury in this case, and I've never objected on the basis of no authentication. So I objected, and the transcript is clear. He never answered any question. You sustained objections that it was beyond the scope of his direct examination. So while it's great to mark things, and while it is true that is in fact Cellmark strip, we do have rules. They're called the California Evidence Code, which dictate what the jury can see and in what form they can see it in. And it's simply us asking you to apply the rules.
That's not, Mr. Harmon is not stating accurately. The court can look at itself at the transcript at page 28683. Mr. Sims said he was familiar with this strip. Then, when he indicated that he didn't feel competent to make an opinion about the strip, objections were sustained to my going any further with it. Now, that's different. As to whether he's conceded, I showed him this, he said, yes, that's the strip.
All right.
I'm
I'll
not
take a
sure
look
it's
at
a big deal, but the point is that as a legal basis, it's admissible. As to striking any further testimony, he said in terms of his ability to read polymarker strips, well, that's another thing that's already been done.
All right, 1183.
With respect to 1183 and 1184, 1183, and we can check this, I think is the same thing you just dealt with on 1154 and 1155. These are the California Association of Crime Lab Directors report and the Cellmark letter in regard to the blind trials. 1184, I believe, is the Thompson article about the CACLD study, and we withdraw 1184.
All right,
If I'm right about what those things are.
Yes, you are. This is 1184, it's Dr. Thompson's article.
Yeah, so 1183 I think is in, and 1184 we withdraw.
All right, any other comment on that?
Yes, 1183 isn't in. The exhibit that was shown to Dr. Cotton is in. And if you look at the testimony of Colin Yamuchi, he was asked if he'd seen that, and he said no. And so 1183, as it exists, should not be admitted in this case.
I think what we ought to do, as we've done before, is cross-reference them so the jury knows that the whole point of it is that he didn't know about it. And we're talking about the same set of documents. That is, the report from the California Association of Crime Lab Directors, and the Cellmark letter. Our point concerning their false positive errors.
All right. What we'll do is cross-reference this. Okay, 1191B, which I think is a duplicate of 1158, if I'm not mistaken. This is the Fung and Mazzola D1S80.
Mr. Clark says he's looked at it, and subject to his representations and checking it, we have no objections to 1191A, well, 1191A and B are supposed to be, if you put them together, the D1S80, DQ alpha, and polymarker genotypes for Fung and Mazzola, right?
Well, and other personnel.
So if that's what it is, that's fine with us.
Okay. Mr. Clark? $1191A, no objection?
Could we see that quickly?
All right, Mr. Clark, Mr. Harmon, what's your status on these? Actually, 1191 and 1192, excuse me, 1191A and B.
No objection.
All right. All right, the record should reflect that Exhibit 1195 has been withdrawn. Exhibit 1197, 98, 99, 1200, and 1201 likewise have been withdrawn. All right, next matter that's contested is 1205. The letter. Submitted? Sustained. All right, 1207 has been withdrawn. 1215 is the Amplitype User's Guide.
The only objection is to the material other than what was used with the witness regarding the 1.2 mixtures.
Mr. Neufeld, Mr. Scheck?
I'm sorry.
On 1215, the Amplitype User's Guide, there's no objection to the paragraph that was used. However, there's an objection to the extraneous material.
I'm sorry, this has to do with the mix, is that right?
Yes.
I think that's fine.
It's not a paragraph, though. It's actually a couple of pages that deal with it. And certainly to the extent that it only deals with the mixture and the 1.2 problem, we'll so limit it.
All right. All right, then I'll overrule the objection subject to the redaction for that purpose. All right, refresh my recollection. Who handled Mr. Diedrich?
I did.
All right, 1220.
Do you have that visit, Your Honor?
I'm sorry, Your Honor, do you also have do you also have a note that we withdrew certain exhibits?
I'm
From
sorry.
yesterday, informally, we withdrew certain exhibits.
Yes.
For Bruce Weir. You've already
Yes.
so indicated?
Yeah, we went through that about 3 minutes ago.
Oh, all right.
Okay. All right, Ms. Clark, as to 1220.
Right. The objection is that there's no relevance to it. That was a system of classification of hairs and fibers not used by Mr. Diedrich, nor was it shown that it was used by any witness or expert for the defense. It's a system of classification of characteristics that assigns numerical values or assigns a number to each of the various characteristics for the purpose of attempting to categorize, but there was no foundation laid to establish that it's an accepted procedure in the scientific community at all. In fact, to the contrary, Mr. Diedrich rejected it.
Mr. Blaser.
He did testify that he remembered reading, he disagreed with the numbering system, that's accurate, but he agreed that the list of characteristics that were described on there are characteristics that he looks at. I would submit it on that.
I'll overrule the objection on that one. All right, 1221.
Your Honor, you skipped 1217. You're overruling that objection on 1220?
Yes.
There was no
12
foundation laid by the defense, Your Honor.
Counsel, I've heard the argument. There was no objection lodged to 1217.
It is in my list. Mr. Cochran?
It's a worksheet, isn't it?
Mm-hmm.
When we went through this yesterday, this was not on the list, but
It's in my August 7th letter.
I agree it was, but yesterday they didn't have it on the list. I'm happy to deal with it.
All right, 1217.
That was irrelevant. That was a worksheet marked by Susan Brockbank, but did not involve any of the evidence she testified to.
It was an example of the worksheet that they used to classify hairs. That's what it was intended for. I agree it was not any hair that was used in this case. That was why I introduced it as an example of how they classify hairs. There was no objection to it at the time. She authenticated, this is the form we use.
All right, the objection's overruled. All right, 1221. Twelve 1221 indicates that it's one page, appears to have 2 pages.
I'm not sure why page 2 is there. It shouldn't be.
It appears to be, Mr. Blaser, it appears to be your notes.
No, this obviously is second page.
Well, B and C you probably want.
Well, yeah, we can cut off the bottom part.
All right, Ms. Clark. All right, you withdraw the objection subject to the cutting off of the bottom.
Yes.
All right. 1221. And I'll staple the 2 parts together so they don't get lost. All right, 1222, FBI Hair Guide.
I need a page cite on that. See.
182, line 11. Just
Sure. You want to see this?
I know what it Maybe I don't. Are you holding it? Oh, this is yellow, okay. It's on.
All right, 1226 has been withdrawn. I'm sorry? All right. That'll be sustained. Okay, 1233. This is Mandel and Aronson.
May I interject, Your Honor? People's Defense 1227. Mr. Darden wanted to interpose an objection to that photograph.
That's the photograph of the defendant and
The night before?
the night before. We'd object on the same grounds as earlier this morning with regard to 1003. The defendant posing for a photograph, in our opinion, has no probative value. It's misleading to the jury.
Smith.
All right, objection is overruled. All right, 1233. We might as well take up 1233 and 1234, same time.
I have a discrepancy here. I interposed an objection to 1233 that was described to me as an article on the selection of non-correlated thin layer chromatography,
All right.
chromographic solvent.
No, 1233 is the printout of Ellen Aronson's route from her apartment to the Mezzaluna restaurant, 1234 being the route back.
Your Honor, then we've skipped a couple of the objections I needed to have on the Diedrich exhibits because I had them they were misnumbered in my version, 1223 and 1224. I had objections to. They were misnumbered in my.
Okay, well, let me do this. Since I've got these out, 1223 and 1234, do you have any objections to these?
Oh, those routes. No.
This
No.
is here, Aronson and...
Right.
Okay.
No objection.
All right, let's go back then. You want to go back to 1223
Yeah, I'm sorry, Your Honor.
and 1224?
Mm-hmm.
All right, 1223 is the, appears to be the Golding and Cocotte, K-O-K-O-T article. Golding.
Is it entitled The Selection of Non-Correlated Thin Layer Chromatographic Solvent?
That's it.
Okay. Yeah, there'd be an objection to that, Your Honor, as being hearsay irrelevant. There was no foundation. It was an article shown to Mr. Diedrich that he did not, I believe, demonstrate familiarity with. There was no adoption of it. There was no reliance on it, nor was it even impeaching.
Can I take a look at it, because that wasn't on my list?
All right, withdrawn. 1224 is the...
Thank you. With respect to, should I put on the almost so I can talk to you and you can see it at the same time?
Oh, I'm familiar with it.
Okay. On the,
Why don't you use the microphone so the court reporter can get you? Ms. Clark.
I'm just waiting for Mr. Blazer so you can hear my objections. First of all, with respect to all of these slides, they're argumentative, and they should not be admitted as evidence. If they wanted to use them as argument boards, I think that would be fine. Secondly, with respect to the gloves, the gloves board in particular, board or slide in particular, is incorrect. It said that there is no hair consistent with O.J. Simpson on the Rockingham glove. That's incorrect. There is a black limb hair that would be consistent with Mr. Simpson. That is consistent with Mr. Simpson, rather, in the testimony of Doug Diedrich.
All right, so the only factual inaccuracy, or as far as the record is concerned, is which one of the slides? The Rockingham glove slide?
Yeah, actually, it's a both gloves slide. That's incorrect.
What's the other inaccuracy?
It's all on one slide. The
I see.
slide's entitled Both Gloves. And it's incorrect with respect to the assertion on the Rockingham glove.
Any other factual inaccuracies that you're alleging?
No.
All right, Mr. Blazer?
I think we went through this when this was shown. I believe the testimony was that they don't classify limb hairs, and certainly this, they can say it's negroid, but that's all. And I don't believe that he testified that, as with the other hairs with other characteristics, that he's willing to make any kind of assessment on this one. But we went through this at the time this was shown and introduced. And,
There's a distinction between how definitive he could be in his conclusion with respect to limb hairs versus head hairs, because head hairs have more characteristics. But it is correct that the limb hair found inside the Rockingham glove is consistent with limb hairs of with having come from Mr. Simpson. So this is a misleading assertion on this slide.
I don't think he ever said that. And I know this was discussed by Mr. Bailey, because I think the issue came up at the time that we used that. And I believe there was even a bench conference about it, where the court allowed it on the basis that they don't classify limb hairs, even though they can tell the race, that that's not the same as head hairs, where they have a lot of other characteristics to look at. That's my recollection.
See, I don't remember what the bench conference was, Your Honor. I just know that, given the witness's testimony, that the limb hair in the Rockingham glove could have come from Mr. Simpson. In view of that testimony, it's misleading to say no hair consistent with him.
Do we have any reference in the transcript where this is discussed?
We're going to have to dig it up, Your Honor. It would be right in there. It'll be right in there.
I'm almost positive this has been covered. Do we pass on this one?
Yeah, let's pass on it for now, and I'll pull the, it'll be volume 181.
Mr. Scheck says he's got it.
Well, we've got the reference to the number, but I'm not sure that's what we're looking for. I can find it.
Okay. All right, 1235. Thank you.
What is the date of this statement, Your Honor?
I'm sorry, the date of this statement?
Right. It says Statement of Ellen Aronson,
Yes, it is.
and is that, okay, that's, yeah, July 8th.
This is a subsequent telephonic July 8.
Interview with Detective Kilcoyne.
Yes.
And the people's objection to that would be hearsay.
I think, Your Honor, it's offered to rebut a claim of recent fabrication. It also has sufficient guarantees of trustworthiness. I believe, although I'm not certain, this was offered on redirect after there had been a spirited cross-examination about some of the times, the confusions about the hours on the Metzalina clock, whether or not she had recalled accurately what times she had left, and the substance of a subsequent conversation with the detective when she sought to correct misinformation that she had been given earlier. So I think for these reasons it's admissible.
Well, my list of exhibits that I have in front of me doesn't show it, but was her initial police report admitted in the statement she gave on June 15th?
I don't believe so.
It wasn't offered.
Oh, yes, it was marked by the
What?
people. The point being, Your Honor, that this would not be admissible under that theory unless the people had marked and admitted her initial statement as a prior inconsistent statement.
No, I think that if you attack somebody's testimony at trial, then the offering party can bring in a prior consistent statement.
But it doesn't qualify as a prior consistent statement because it was not previous to the inconsistent statement. You know what I'm saying?
What?
Yeah, I mean,
I know what
I
you're
think it was, it sounded confusing to me. But she made a prior inconsistent statement on June the 15th. That was her initial statement. She then changed it after the preliminary hearing on July the 8th. So that was the statement that was consistent with her testimony at trial. It doesn't qualify. It's not prior in time to the inconsistent statement.
It's consistent with what she said on direct. She was then impeached on cross-examination, and she offered a prior consistent statement to what she said on direct.
That doesn't satisfy 1235 or 770, Your Honor. That doesn't meet the requirements. It's got to be prior in time to the inconsistent.
All right, 1236 of the Evidence Code says evidence of a statement previously made by a witness is not made inadmissible by the hearsay rule if the statement is consistent with his or her testimony at the hearing and is offered in compliance with Section 791. Thank you. And Ms. Clark, just so you can cross-reference your own records, the prior statement that was put in by the people as People's Exhibit 495 is the June 15th statement of Ms. Aronson. So there are under 1236 and 791, I'm going to overrule your objections. Okay.
Back to 1234. I found the page in the transcript where that was all discussed.
All right, give me the page number, please.
35340. Same objections were made and they were overruled.
Okay, 1237. I'm sorry.
What was the, I missed it.
35340 was the page site on,
Okay.
we'll come back to that. All right, 1236.
Was there objection to 1236?
I show in my notes that objection to 1236 and 1237.
I see 1236, Your Honor.
1236 is the September 12th
Interview by-
statement by Aronson.
September 12th, that statement doesn't qualify. Under 791, I mean, it's the same problem. The evidence of a statement made that is inconsistent, that has been admitted, the prior consistent statement has to have been made before the alleged inconsistent statement, which was on June the 15th, which obviously it was not. Secondly, before the motive to fabricate has arisen. And the people's position clearly is that this was a groupie who wanted to get herself injected in the trial, and that motive existed at the time that she recontacted Detective Kilcoyne and realized it was going to be a very high-profile case, which was on July 8th, and she began to restructure her testimony to make sure that it would be relevant. That's the motive. Now, September 12th certainly is not prior to that time, nor is it prior to the June 15th prior inconsistent statement. And the people submit that it does not qualify under 791.
I submit on the early comments, Your Honor, I think the rulings are consistent.
All right, objections overruled. 1237, phone bill. Ms. Clark.
Hearsay and irrelevant.
Why? One, Your Honor, certainly I think it's very relevant because it helped to explain why Ms. Pilnuck was certain that various acts occurred at different times. I think that it is, in fact, a bill from the phone company. We have been introducing these sorts of documents by stipulation and other forms. I don't think that there is any sincere challenge to the authenticity of the bill. I think it offers sufficient guarantees of trustworthiness for its admissibility. But she was, as you will recall, she was very exact in recounting what events occurred at certain times, when she called her mother, when Ms. Thielander had left, and that bill corroborated the specificity with which she offered her testimony.
My recollection is that she testified that this was her phone bill.
Correct.
All right, the objection will be overruled. All right, 1240.
Hearsay objection.
That objection was, the document, Your Honor, was offered to demonstrate Mr. Heidstra's state of mind that when there was an occasion with he and other witnesses to recount and to go through various observations from June the 13th, that there was, in fact, his state of mind not to discuss with other potential witnesses. It reinforced our claim that he was not biased, that he was not polluted by the presence or potential testimony of others, particularly with Mr. Heidstra. That has become a very real challenge. I'll simply remind the court that, as far as I understand, 4 of the first 8 names that we were given of rebuttal witnesses were witnesses seeking to rebut Mr. Heidstra. His credibility, his bias, if any, are therefore rising themselves in importance, at least from the people's version of the evidence, and this supports or attacks any suggestion that when we tried to gather people together to go over certain steps and observations, that there was no polluting.
Well, it's not relevant relevant for that purpose is a letter from Mr. Bailey to Mr. Heidstra. I don't know how that impacts on, that illuminates us as to Mr. Heistra's frame of mind or his veracity or credibility at all.
All right, thank you, counsel. The objection sustained. All right, 12:50.
I'm sorry, Your Honor, we have to add 1241. It was inadvertently left off of our list. It's a two-page statement of Mr. Heidstra.
And I'll offer the same comments and adopt those comments that I offered as respect to Ms. Aronson. Again, Mr. Heitstra's credibility will be viciously attacked, strongly attacked. I don't want to characterize it. And this is a prior consistent statement offered to rebut a claim of recent fabrication that he is fabricating at this hearing when he testified as he did.
I can assure the court that Mr. Heidstra's credibility will not be attacked viciously. In fact, we think Mr. Heidstra's testimony is very helpful to the prosecution. And in fact, what we intend to do is buttress Mr. Heidstra's testimony. Still, however, it is hearsay. It is an out-of-court statement. It was alluded to somewhat during the trial. That is what he had said previously, and he testified on the stand to what he had stated previously.
Testimony. But I certainly think, we'll take that up later in our next motion. But I certainly think that, Your Honor, this is being offered to rebut a claim of recent fabrication that he might have had some motive or bias in favor of Mr. Simpson.
I understand that, but the objection that Mr. Darden made, though, was foundation because this was a statement taken by Detective Payne and Detective Parker, neither of which testified.
Your Honor, I believe, and I don't have a specific recollection of where this exhibit was discussed. I believe Mr. Heistra was asked about it. He then agreed that the statements that contained in that statement were accurate and that it accurately reflected what he had told them on that day.
I'm not sure that allowing this statement in would be consistent with the court's earlier ruling on the Aronson.
And I note at the time, Your Honor, that it was offered on page 36435, and there was no objection at that point.
46435?
36.
36. All right, I'll take a look. All right, 1253. I'm sorry, 1250. Video of 1250. Video of Mr. Simpson arriving at Rockingham. Was this the videographer who testified to this?
This is Mr. Thompson, Your Honor. The tall gentleman who put the handcuffs on Mr. Simpson. He testified and authenticated the accuracy of what was depicted there.
Ms. Clark?
Was that subject to redaction?
All the videos have been subject to redaction to that extent that they were shown for the jury.
I know there's a one attorney rule, but there was the issue, I think, of the sound. There is sound in that video, which was not aired for the jury. And so
Then we can do what we did with the Mazzola demonstration video and have a little post-it put on there that it should play without sound.
as I understand, the video contains only the. Does it contain
All right,
only
only the portion that was displayed for the jury and without sound as to both 1250 and 1251. All right, 1252 has been withdrawn. 1253.
Those videos at Rockingham, there was no videographer called.
I know. I asked if Mr. Thompson was the videographer, and my recollection was refreshed by Mr. Douglas's comment that it was Officer Thompson
Right,
who testified to the videotape.
right.
Okay. All right, 1253, vehicle impound form filled out by John Moraz.
Your Honor, is hearsay and lack of foundation. He only filled out a small portion of that. The balance was filled out by other witnesses who were never questioned about it or able to authenticate it.
I think, Your Honor, that this is in fact a business record. It certainly carries sufficient guarantees of trustworthiness. I don't think that the people are suggesting that it is inaccurate or that it is misleading because it is a document that was used for the purposes of the police department. Mr. Moraz did in fact identify those portions of the form in his penmanship and those portions which were not. Submit the matter on that.
The foundation was not laid for a business record at all, Your Honor, and it was incapable of being laid because they never called the appropriate witness to do so, and I would not vouch for some of the writing on it because it was made by people at Bertel's and based on what may have been misunderstanding between them and police officers. So, no, absolutely not. I don't concede at all that it's trustworthy or reliable, and there was no adequate foundation laid with the appropriate witness to have it admitted as a business record.
But, Your Honor,
Excuse me, counsel, which portion of this form did Mr. Moraz fill out?
I recall for sure the top half, and I believe there was something toward the bottom. If I could see the form just to refresh my recollection.
While Mr. Douglas is looking at it, it will assist the court with respect to the Heidstra, pain statements for Heidstra. I've looked up the transcripts, and it's starting at page 36.
Why are you referring to a styrofoam cup, sir?
That's where I wrote down the numbers. If the court, to assist the court, starting at page 36438, and then going to page 36446, the entire statement is read into the record during the course of questioning Mr. Heidstra, and he adopts it, and it's read in with quotation marks.
Your Honor, this is also being offered to corroborate Mr. Moraz's state of mind.
All right, no, Mr. Douglas, my question was, what part of this document did Mr. Moraz fill out?
The top.
I would point out to the court there are many different handwritings on that document.
Go back to the transcripts. My recollection is that his testimony was that this is a document that's filled out in the regular course of business through Vertel's and the police department, that when he received the document, he had seen Detective Harrow fill out a number of the entries here. He then signed in the middle line where it says garage employees, and I think he then put down the license plate number and reviewed the rest of this material. So we're offering it as a business record with a proper foundation there. When we get to the transcript, we can, I know that he specifically testified as to which parts he filled out, but he adopted the rest of it. He explains who filled out what.
Your
He
Honor,
can't
if I-
adopt the rest of it, Your Honor. He can't vouch for someone else writing on that form or the veracity or trustworthiness of it, and they did not even attempt to lay an appropriate foundation. It's inadmissible.
It's on page 38260, Your Honor. It would also be offered as an alternative to reflect Mr. Moraz's state of mind that there was no hold then preventing or requiring that the vehicle be placed in a particular area, the secure area, and that
But
was...
really, aren't we really quibbling over something that is of little moment? The issue being, he testified he didn't see blood, and he didn't think it was being held in a secure area. That's really the import of his testimony.
The other basis for admitting this that Mr. Douglas referred to has to do with the direct examination of Detective Muldorfer at 38259, where she indicates that she conducted an investigation, interviewed the principal parties, and determined that this was the form that was filled out, and even then went into detail as to who signed what. And she authenticates this as an official business record of the garage and talks about the rules. And I put her on the rules with respect to what parts of this are supposed to be filled out and for what purposes. So we think that Detective Muldorfer's testimony is the citation of the pages we told you would be sufficient foundation. She described at length what these impound forms mean.
All right,
she's
where is,
not the
excuse me, where is that?
It starts on page 38259. I think she certainly is a proper witness. It was her assignment.
Would be allowed to complete
Wait,
with?
wait.
I think that the foundation is that she testified that she was assigned in the city attorney's office to investigate
I
these
recollect who she
garages,
is.
that she was familiar with their rules of procedures. She also proffered a series of lists talking about rules and procedures.
All right.
She authenticated this form and others and found Vertel's in violation.
All right.
So I think her testimony lays a sufficient foundation for this as a
She's
business
not the
record.
proper witness for that form. She's not the one who uses it. She's not the one who filled it out. You need to call somebody to lay a business record foundation to establish that they're familiar with the form, the manner in which it's filled out, and establish its trustworthiness, and she can't do that. She may recognize the form, but she's not familiar with the manner in which it's filled in and who has to fill it in, the people that are under a duty to do so. And the problem you have with this particular document is there are a number of people who've put in information on that form. At the very least, if the court is going to admit it, then the form should be redacted to include only that part that Mraz wrote on, to, if they want to use it for that, corroborate his testimony. But the part that is filled in by others who are under different duties than Mraz should not be admitted, because that cannot be vouched for with the testimony that we have.
All right, I'll look at the transcript.
If I may
All right,
just...
1257. Ms. Clark.
Passing, Your Honor, just so the court is aware, the section that Ms. Clark is concerned about is the box at the top that says, "Give no special care," and I just want the court to know,
Counsel,
we'll
I've-
reopen
I've-
our case to put this in.
I've concluded the discussion. Thank you. All right, EDTA slides, 1257. Ms. Clark.
That was all the slides, 1257A
Correct.
through S. The objection, Your Honor, is 352. It's misleading and confusing. If the court will recall, there were a number of charts that were shown to Dr. Readers that the ion wars. I remember that
The daughter wars.
yeah, the daughter wars. And I still haven't figured out why they have no sons, but they compared
I
different
wondered that
days on some
myself.
of the charts, Your Honor. There was also a confusing juxtaposition of different results obtained at different times. And the problem that we had with all of those slides was that it was misrepresentative of the actual results that were obtained. Now, given the fact that they did not do any testing to justify the manner in which they put these together, there is no reason why Agent Martz's testimony indicating the misleading nature of those slides and the juxtaposition of those results should be disregarded. The only real testimony you have concerning how the results should be viewed and in what way they should be compared with each other is Agent Martz, because he was the one who operated the machine, he was the one who ran the tests. Dr. Readers did nothing but look at his charts and his graphs. And the problem is, as you recall, that Agent Martz testified that the machine, the column is very sensitive. It will run high one day and low another. And so you cannot compare results from one day to the results of another. In fact, you can't even compare results from the morning to the evening because the column is so sensitive. The tests have to be run at the same time, or within minutes of each other to be valid for comparison in terms of concentration of the ions. And the problem with these charts, as I recall, is that they did not do that. There were different days and different times put together in an effort to mislead and make it look as though there were discrepancies where there really weren't. And there's no basis for doing that. In fact, it's very misleading and confusing to the jury.
Mr. Glazier?
Well, I think Ms. Clark is talking about other slides. 1257 was the first set of slides. It just illustrates what the process of chromatography is, and it was, each slide was gone through with Agent Martz, and if there were two charts and from two different days, that was explained to the jury. I'm not sure which, I think she's talking about some later charts, but this was all gone through with the jury. Agent Martz was allowed to explain anytime he disagreed with anything, and I don't see what the problem is.
Maybe try to see.
Well, I think it's a combination of both how the mechanism works and the specific results of testing, in this case by Agent Martz. I think we have both of those here.
Right, okay. I'm looking at A, B, C, D, E, F. I think so far so good. Through L is okay, withdrawn on that. A through L withdrawn on that.
All right.
Here's one, 1257P. So far I've gotten through O, there's no objection. P is a problem, Your Honor, and the reason it's a problem is that it assumes something that is not in evidence. That is, the location of where 206 was taken from. Right. 206 and 207, both. No one knows exactly what area of the stain those came out of. It's never been established. This makes an assumption that one was taken out of the corner of the stain, corner of the cutout area, and that 206 came out of another spot. In other words, it makes an assumption that 206 and 207 came from different areas of the stain.
All
And
right.
we don't know that up to be true at all, so it's very misleading. In fact, they might very well have been on top of each other, right next to each other, and that is important in
All right.
terms of the concentration.
May I see that, please?
Yeah, there was testimony in 206 that that's approximately where it came from. There was actually a picture that showed the cutout. 207, I would agree with Ms. Clark to the extent that we don't know whether it came from the lower corner there, and that was explained by Martz that I don't know if it came from that corner, but it came from the large cutout. So that's all it kind of illustrates. I think that was
Right, I think Bob's correct. The problem that we have, though, is that as it's depicted there, it's very misleading because a jury's not going to remember how Agent Martz explained it or didn't explain it. They're going to have a big picture back there or during argument that purports to place 207 where it's never been established it was. And that is an important point. It's not nitpicking because where 207 came from in relation to 206 is important in terms of the concentration of blood.
But it was all explained. I mean, there's nothing misleading about it. They were told that we don't know exactly where it came from the cutout. It's just to illustrate that it was part of the cutout.
All right, but this slide can be modified, correct?
Sure.
If Mr. Glazier would take out 207, just take it out of the photograph, then I wouldn't have any objection.
All right. I think what we can do is label that 207 came from somewhere in the green area.
Okay.
And
All right.
take that box out.
Take that box out.
Great.
All right. This is 1257P. Aren't you keeping track of these things?
I lost my track.
All right. All right, Council, we're going to take our recess at this point, and we'll stand in recess until 2 o'clock.
Your Honor, just some clarification. on for this afternoon. You have another motion on this afternoon.
Have to finish this first.
Okay, and not only do we have to finish this, but we also have to finish the scope of rebuttal. And we have specific discovery problems regarding
Right.
that as well that must be resolved today. Because as you know, they want to commence their case on Monday. And they had really...
Counsel, you don't need to argue it now. I'm aware of all these matters we have to take up, and we'll start at 2 o'clock. But we will finish this. All right. All right, back on the record in the Simpson matter, all parties are again present. Jury is not present. Where were we? 1251-ish. And counsel who are here for the motion regarding access to tapes, et cetera, I've got to finish this first. So if you want to take an hour and get a cup of coffee, be my guest. Yes. All right, Ms. Clark, where were we? We had gone through P, as I recollect.
That's right, Your Honor. We got up to 1257Q, and I asked for Xerox copies from Deidre to look at over the lunch hour. Unfortunately, the Xerox copies don't tell me the date and the stuff that I need to know to identify the charts. So I thought it was a good idea at the time, but it didn't quite pan out. So if I could look at the originals again to see if I could get a little more detail, unless Mr. Blazer could tell me offhand, you know?
No, I don't have.
Thank you, Your Honor.
We don't have, I've excused our Elmo operator.
Oh,
I don't need to see it on the Elmo.
no, I do, Your Honor. I can't, because it's too small. And I can't tell which charts they are. I can't read. That's,
Here, let me give you my magnifying glass. No, Mr. Ormond, I gave the rest of the day off. I didn't think we'd be using that.
there's no reason to think that we would. Actually, Henry Lee gave me his. I should put it down. Marked, that will
Do you want to pass this whole series?
yes. Come back.
All right, how about 1261? Bar chart, EDTA.
withdrawn. Objection withdrawn.
All right, objections withdrawn to 1261, 1263. A letter from the DA's office to Special Agent Roger Martz with lots of writing on it.
This is the one.
Do we have a clean copy of that?
Yeah, we can substitute a clean copy.
People's objection is that it's hearsay and it's irrelevant. Objection that it's hearsay and it's irrelevant, Your Honor. I think it was offered to show bias on the part of the witness. That letter would not go to the witness's state of mind, it would go to the writer's state of mind, assuming that it showed any bias, which it doesn't. It asked for the receiver of the letter to detect the presence or absence of EDTA without indicating that a particular result should be obtained.
Mr. Blacher?
Well, that same objection was made at 38627 of the transcript. It was overruled at that time. I don't know if there's anything new about it.
Well, I overruled I allowed its use for examination of that witness, but that witness was not the author of the letter.
No, that's correct, but it demonstrates what he was told. This is what we want you to do, and it's relevant to his state of mind. It's not offered for the truth of the matter stated, certainly.
All right, the objection will be sustained. All right, 1267. The food iron absorption article.
This was the,
1267.
right, this was the article that had been referred to by Dr. Reeders as, in his attempt to say that there had been a study that had been used to determine the average daily amount of EDTA that would be found. But he wound up having to concede that that, in fact, was not shown by the study at all. The study was for a different purpose, and it was, what they did was they injected EDTA for the purpose of determining what would be left after certain periods of time, but that does nothing to indicate what trace amounts would be found if everyone's blood was tested for various types of EDTA, so it's very misleading. I believe the court initially had ruled that he could not bring that article out and could not be questioned about it, and then Dr. Reeders just kept talking about it, basically. I mean, he wasn't even listening to my questions. So I think the court earlier ruled that it could not be used, and we simply urged the court not to allow its admission. It is irrelevant, it is misleading and confusing, as Agent Martz indicated as well, when he had to go back and try and unravel it.
Ms. Clark's confused. She's talking about 1268. 1267 is the article about the average person, the maximum daily intake of EDTA in a diet would be 50 milligrams, and that would lead to a certain level in the blood. But as to both of those exhibits, Agent Martz testified. In fact, he was the one that was asked if that's the article he relied on when he gave that figure of 50 milligrams a day, and he said yes, it was. 1268, the article, the absorption article that she was talking about, also was testified to extensively by both Dr. Reeders and Mr. Martz. They both relied on it. They relied on it for different purposes, but it was extensively discussed, identified by both of them, and relied on by both of them. They disputed what it showed, certainly, but it doesn't detract from the fact that they both relied on it.
Well, the fact that they both relied on it, though, the fact that these are both scientific articles out of scientific journals, I mean, isn't there a danger here that Dr. Reeders testified, Agent Martz testified, and you have exhibits that say what their testimony was. I mean, why do we need these articles?
Well,
I mean, do you seriously expect the jury to go back and to read scientific journal articles?
I don't know. I would hope not, but I mean, they were referred to. They were read in. Parts of them were read into the record If they have any confusion about which doctor was, whether Dr. Reeders was right or Agent Marks was right and what those articles said, they might want to refer to them. The fact that they probably won't, I don't think is a reason to not have them admitted. And we might want to make reference to them too in our argument.
With respect to, I'm sorry to interrupt, but with respect to 1267, that was, I just got my memory refreshed. That was the FDA listing of EDTA amounts in food, and the people withdraw their objection to that. I've just been shown the reference in transcript, but we maintain our, but Mr. Blazer is correct, 1268 is the one that we have the objection to, because, and that is completely misleading. It was, Dr. Reeders attempted to use that article to buttress his position as to what if any, amount should be found in people on a normal, regular person on a daily basis. And in fact, it does not direct itself to that at all, which is why it's so misleading and confusing, and not to mention
All right,
very
this is the
complicated.
article that deals with the injection of EDTA.
That's right, 1268 does. I'm sorry. So,
All right, not only are they confusing scientific articles, we're confused as to which one is which, correct?
I'm not.
All right, well, Ms. Clark and I are confused as to which one is which. All right. I will sustain the objection as being irrelevant, because this does deal with injected EDTA, not ingested EDTA. All right, next. Cambridge Isotope Laboratories, 2 pages. This is the catalog that shows that EDTA compounds, as research compounds for testing and comparison purposes, correct?
No, that there was an internal standard readily available.
Ms. Clark.
the objection I had down was insufficient foundation and hearsay. And I can't remember what Dr. Reeders did to lay the foundation for it now. It escapes me.
Testify about it at all. It was Agent Marks who was shown the catalog, testified that he recognized this is a catalog from Cambridge, and looked at that page in the catalog and said, yes, that does look like an internal standard that could be used, and described what the price was.
$250 if I recollect.
Right,
Something like that.
Yeah.
right.
All right. Objection will be overruled. All right, 1271A through C. Ion counts.
Yeah, maybe I can shortcut this. The third slide was a demonstration slide that I did adjusting some of the quantities. It doesn't reflect actual test result, it reflects those multiplied by various numbers. I have no objection to that not being given to the jury, but I certainly think we're entitled to argue that. I mean, that's something we could present an argument. But since it didn't result, any specific results from any test, I have no objection to withdrawing that, with the understanding we could still make the argument, of course, and show it in argument.
Ms. Clark?
Okay, and let me make sure, if I can look in the transcript very quickly, for A and B, I may withdraw.
All right.
Let me see.
I believe those two are just straight charts that Mark's identified.
These are the charts, Your Honor, that have the different days.
Yeah, they were objected to on that grounds. I think we added the dates to them.
Do you need the magnifying glass again?
No, I don't, thank you, Your Honor. I probably should get glasses. These, as to A, Your Honor, we have here the juxtaposition of February 22nd and February 28th for the same,
Are they marked as such?
they are, and I'm not disputing that they aren't, but with respect to B, no, these okay then. Yeah. Yeah, can we just pass these? I may withdraw the objection. I wanted to see what Agent Martz said about these two slides. And if we don't have to argue an objection, I'd like not to. I have, Ms. Martinez will find the part.
Okay, then we can move on to my
Yeah.
second favorite objection. Socks.
It's just a brown sock. And the relevance would be
Socks.
socks. Yeah, they're not the same as the ones in evidence. So what's the relevance?
The exclusive relevance of the sock was simply to coincide with the testimony of Herb McDonald to enable him to explain what surface 1 is, surface 2, and surface 3. If it isn't obvious to this jury that it isn't the same sock and it's being offered only for that purpose, it would be truly extraordinary.
I don't even think this needs to go into the jury since everybody knows what socks are.
Fine, Your Honor.
Okay, withdrawn. Okay, we actually skip a whole page. 1317.
Oh, I'm sorry, so 1279, is it? what-
Withdrawn.
Withdrawn.
All right, 1317.
Yes, Your Honor, I'm going to keep handling that. That was Michelle Kessler, who testified. This was an item of handwritten notes by Gregory Matheson, which was shown to the witness for the purposes of refreshing her recollection. I just reread the transcript, relevant transcript sections. And in fact, it did refresh her recollection that they had had certain meetings shortly after the crime scene was processed on the 13th of June regarding case security. That's all it was used for. The document itself is not an official form. It's not a business record. I don't know why it's being offered.
I'm just curious, was this considered listed on as one of the objected items yesterday? We'll withdraw it.
All right, withdrawn. Mr. Robinson, you get that? All right, thank you. 1318.
Your Honor, this was the memorandum from Chief Gates that I believe was 24 years old.
No, it's older than that. It's from Assistant Chief Gates.
Oh, it was? Okay. And I also just checked the transcript on that, and there was...
We'll withdraw it. We'll withdraw
Okay.
it.
Withdrawn.
Although it was a very interesting document.
Aren't they all? 1319.
Your Honor, I make the same objection that I previously argued this morning with respect to the collection.
You've already admitted
memos.
these.
I'm sorry?
This is the same collection memos.
You've already admitted it.
Isn't this collection
Same,
and
yes.
preservation of body fluids?
Yes. All right, 1320.
Is the summary that was done in preparation for the Griffin hearing, which was a typewritten summary. This particular document was not a business record, and it was generated by Greg Matheson. There's a very similar or identical document, I believe, that was actually testified to by Greg Matheson, which came in since he was the witness that created it. But this particular version of it, typewritten version, cannot be authenticated and not fall within any exception to the hearsay rule.
Your Honor, my understanding, my recollection was that she did authenticate it. In fact, it was authenticated twice. She testified to this typed version of it, at that hearing before Your Honor last summer, and it was the same report that was shown to her on the witness stand in front of the jury. And it was a typed version that she participated in the preparation of. I disagree with Mr. Goldberg's recollection of this.
All right, anything else?
No, I think the foundation is there, the authentication is there.
Just ask the court to reread the transcript, because this particular one was prepared by Mr. Matheson. She was present, but when the handwritten version was made, and the handwritten version, as I recall, was in evidence.
All right. All right, the objection will be overruled.
Objection to what?
Overruled. 1329. This is the photograph of 112 blood spot.
This was a substitution question.
Your Honor, on 1326B, according to my notes from our discussions yesterday, the defense was going to withdraw that.
That's correct. 1326B is withdrawn. All right, 1329.
These were items that the prosecution, 1329 and 1330, the prosecution wanted to have permission to cross-reference and put post-its on. Other than that, we didn't have an objection to them.
All right. Do you know what cross-reference that should be to?
Well, I think that the cross-reference for 1330 is 1098, and I don't have a cross-reference for 1329 yet.
All right. 1330. This is the one, this is an Elmo printout where the detail on the door sill is lost in the Elmo process. So we are going to cross-reference this to the actual photograph. Do we have the number to cross-reference that to, and I can put a post-it on it?
You just said 1330, Your Honor?
1330.
That's the one that, according to my notes, is
1098. 1098. All right. All right, and Mr. Goldberg, your staff will prepare a label indicating the cross-reference People's Exhibit 1098?
Yes.
Okay. Okay, now I have objections 1331 through 1336.
I'm just going to wait for Mr. Jordan on that, Your Honor, and I need
All right,
to
these
look
are all photographs from Chicago.
We can go back to the EDTA whenever you want to. Well, we have, people mark, I think, similar photographs, if I could see them. Let me show these to you. No objection to these, and in return for that, Mr. Douglas, in the case you will not object to the people's exhibits, let me name for the record some of our 581A, B, C, D. E, F, G, H, I,
All right, objections withdrawn.
Withdrawn in return to that agreement, sorry.
They're the same picture, so I don't object to the entire set coming in.
Terrific.
Oh, and the big one? Did you also move it close to the watch lock in?
I hope so.
Yes, that's it.
All right. We are going to cross-reference 1337 and also 1337C. Mr. Goldberg, that was your suggestion?
1337C, yes.
Right. Did we get another exhibit number?
We don't have that yet, but we will get that.
All right. Okay, then we skip to page 18, 1360. A.
We have 1341. I have a note about cross-referencing that, but that might be difficult. I think that's one of Mr. Lee's boards.
All right, I don't think either side has any problem cross-referencing
Okay.
similar exhibits. Okay.
Okay, and I won't bring those things
All right, 1360A, which appear to be 2 pages of Gary Sims' notes.
Yes, these were, it was a page of Gary Sims' notes that notated some transfers on bindles, and objections were sustained to that when the defense tried to elicit from Dr. Lee what was stated in the notes.
Defense?
Well, my argument is that these notes are notes that Dr. Lee testified that he would generally rely upon from other experts in the field. They're the laboratory notes of the analysis of the bindle. And they document that Gary Sims said there was a cross-transfer. So I think that under the...
Well, is there any dispute, given what we've seen from the photographs, that there were cross-transfers?
No, there's no dispute that there's a cross-transfer, but what's significant is that Gary Sims noted it, and when he noted it. That is a significant evidentiary point.
Mr. Goldberg?
Your Honor, I thought we were not going to relitigate issues that had already been resolved adversely to the party, and I've been trying to stick to that. This is an issue where I'm not positive. I think we may have gone to sidebar, but at any rate, the court did make a ruling and several times sustained objections. We would like the hearsay rule to be enforced. It is hearsay. There is no authentication for it.
All right, objection sustained. All right, 1363.
Your Honor, this was an article that I objected to. And it's our position that when you are using an article from a scholarly treatise, the article itself doesn't come in. However, for tactical reasons, people are withdrawing our objection to this particular exhibit.
All right. 1364. Ms. Clark.
Yes, Your Honor, I was getting it for Mr. Darden. Those were the questions propounded to Officer Furman by Laura McKinney. The problem with it is, Your Honor, that it goes far beyond the material deemed admissible by the court and basically makes reference to what I believe to be sections of the tapes that were deemed inadmissible or responses, or if not deemed inadmissible, were not requested to be admitted by the defense and not known to the jury. So the problem is really that the questions go far beyond the testimony that was deemed admissible by the court. I think it would cause the jury to speculate about what else was said, and the balance of the conversations that were neither proffered by the defense nor ruled admissible by the court.
Your Honor, I take that as being a 352 objection. I do think, however, that it is very germane to the question of what Ms. McKinney was trying to do. Was she simply working on a work of fiction? Was there any realistic components to any of that? I think that the colloquy suggested by those sheets in that exhibit reinforce our claim that when any words were spoken by Mr. Furman and the 42 times that he uttered the N-word, he was not doing so in any sort of character. Rather, he was reflecting more his own personal viewpoints, because the questions speak to different issues and areas of general concern and make it clear that he's not being asked certain questions in any sort of a theatrical or fictional context. I think that's going to be a very important aspect for the juror's assessment of the value of her testimony in this case.
But, Your Honor, the problem I have with it is this. Ms. McKinney was clearly capable of being very articulate in framing her answers to demonstrate what the defense wanted her to demonstrate, which is that he was talking in the first person and not for any fictional character when he used racial epithets. If this set of questions is being asked for to be admitted for that purpose, to establish that he was speaking for himself when he uttered those epithets, then the defense does not need them, because the people will never argue to the contrary. And if anyone needs any further assurance of that, let me state it on the record. I am not going to argue to this jury, nor will I ever tell anyone, that I think the racial epithets were used in a fictional capacity by Mr. Furman. The problem, and so that being given, that concession being given, and will be repeated to this jury, there is no reason to admit these questions, which I think will cause the jury to speculate about what else they talked about that are way outside the bounds.
If counsel is willing, because Your Honor, the negative is not sufficient for our purposes, because the jurors on their own may associate the fact that there's a screenplay, that it's a fictional work based on fact, as being suggestive of more. If counsel were willing to stipulate that, in fact, these were factual statements of his, rather than saying, I'm not going to argue that it's fictional, I want the reverse of that. I want her to stipulate, and then I'll withdraw the exhibit, that in fact these were expressions of his own viewpoint and were not part of any fictionalized role-playing, because the jurors can, on their own, without the assistance of counsel, interpret the answers and the conversations in a manner that will not be accurate and would be misleading. And this exhibit helps to place that in a better context. We're talking about issues of general concern. We're talking specifically about matters that we're dealing with, general attitudinal points of view. There's no question suggesting play a role and tell me what someone would say, and I am fearful that the jury on their own may interpret something that's not true.
Well, the proper stipulation as framed goes a little too far. It's clear from reading the transcript, as the court knows, that there were a lot of times that they were actively engaging in setting up fictional things. For example, the example of a cover-up that Ms. McKinney kept trying to get before the jury was an example of a piece of fiction that she and Mark Furman were working on. That was the situation where a suspect had been subjected to the chokehold or to some beating, and the female officer was expected to cover it up. That was the piece of fiction that they were working on, that she was trying to get before the jury. Nevertheless, what I'm getting at, Your Honor, is this. The defense seeks to have the jury know that when he used racial epithets, he did so on his own because that's the way he felt. I'm not arguing to the contrary. This set of questions goes far beyond that purpose, going into all kinds of different areas and his viewpoints about them. And one of the questions even will assume facts not in evidence, because it discusses his response to a socio-political question that was put to him in an earlier tape. So I would simply urge the court that it's way overbroad for the stated purpose.
All right. I'm going to sustain the objection under 352 because it does in fact deal with many situations that are not relevant to the issues before the court.
Possible, Your Honor, the court will reconsider and have us redact those areas that were not, in fact, discussed in testimony.
No. All right. 1368. A good number to end on. Yes, it is.
Your Honor, 1365, is that duplicative? I'm having trouble.
That was withdrawn.
Okay, withdrawn. Is 1368, what we just need to do is make sure that that is the one that was approved by the court for admission.
I believe it is.
Okay,
Mr.
with
Harris
that-
indicates that that is true.
Okay, if we can simply make sure that there's nothing else on that tape except what the court deemed admissible, then there's,
Ms. Clark is welcome to sit here and listen to the entire tape to satisfy herself.
all right, thank you.
Okay.
If we could go back then to what we earlier asked, as to the DDTA, Your Honor,
Yes.
1271? Now I recall. As to 1271A, in which the dates are labeled, there's no objection. As to 1271B, here's the problem, Your Honor. What it shows is that it shows the gate and the positive control on February 28th, and it shows them to be very different in amount. And it's misleading because the reason for the difference in amount, which is what Agent Mart said, and I'm going to show the court the area of the transcript where he's asked about this, is that this was again a situation in which one was run in the morning, and then there were a lot of runs, like 30 runs that day, and then one was run at the end of the day. The column became desensitized, and so you had vastly disparate readings because of that. This chart makes no effort to explain that, and to the contrary, is very misleading because it does not anywhere indicate that there were some 30 runs in between and hours in between, which accounts for the discrepancy in the amounts, given the sensitivity of the column. And I have for the court the relevant transcript portions.
Well, I recollect the testimony.
And I think that should be our argument, that there was complete testimony about this, and his offered explanation. Our position is that that may account for some of it, but it also shows the imprecision of this methodology that he used. So it's been fully explained to the jury. It's not misleading at all. I mean, they've been told about it.
All right, and what about C? You're withdrawing that?
Yeah, with the understanding that I stated.
All right.
We can argue that certainly. And
Well, we should argue that later. I think we should argue that now. But as to B, the problem is that if a juror gets the chart, all they're going to do is see a very misleading chart that doesn't indicate the difference in the time of day, the separation by runs. It's very misleading. And
All right, I think Mr. Blazer's point, though, on this is well taken, that it does show the imprecision of this type of testing, that if it differs by when the result differs by when you did it in the day and what run it was, something that you should think about.
well, that's true. Then
Right.
why don't we simply ask that it be modified to indicate that one was the different times that they were run? Because that is available information to Mr. Blazer.
all of their charts are different times and different runs, then we should
I
exclude.
understand that, counsel. I just ruled in your favor.
Thank you.
You're welcome. All right. Objections are overruled as to A and B, and C is withdrawn. All right, what else do we have? Other than the ones that we've cited to transcript, that the court has to look for the transcript.
There was, okay, 1224 was the hair and fiber slides that I provided the transcript reference before lunch.
Right. And we did have a sidebar on that issue. I don't think that prevents the court from considering the subject matter again, that people renew their objection. I still think that it is misleading in that it tends to, it
I'm sorry, we're
actually,
talking about 1224?
that's right, Your Honor.
All right.
It contradicts the testimony of the witness in stating that there are no hairs consistent with O.J. Simpson on the Rockingham glove. That is inconsistent with the testimony of the witness.
Okay, I'll take a look at the transcript. So I have still to rule on 1036 1043, 1052, 1132, 1170, 1224, 1241, 1253, 'and that's it. Mr. Douglas.
Your Honor, it doesn't matter. That dovetails into the argument that Mr. Blazer is going to give concerning the proper scope of rebuttal.
No, I just want to make sure, do we concur that those are the exhibits that remain to be ruled upon as soon as the court has the opportunity to review the transcripts?
That comports with my understanding, Your Honor, yes.
All right. Ms. Clark?
Yes, Your Honor.
Okay. Good. That was rather painless for 400 exhibits.
We have to mark some exhibits, Your Honor. We had to renumber them. Ms. Robertson informed me that I had incorrectly marked one, and I forgot to bring down the sheet. I think I forgot to bring down the sheet that says what the renumbering needs to be. I needed to do it on the record.
601, 601, and 602. If you get transfers to paper sheet 602 A through D instead of 601 A through D.
So if I could, Your Honor, the magnetic board that was previously marked as 601 A through E, which was of the interior of the Bronco, remarked as 602 A through E.
So marked.
Thank you. Also, the videotapes of the exercise videos,
Which
we have
one,
the redacted versions here.
The commercial version or the
The outtakes.
studio version, the outtakes?
I don't know. Outtakes. 521A, they've been redacted, I think, as requested earlier. And then the motivational speech for Juice Plus, 522A.
All right, so marked.
Your Honor, at a time of convenience, can Mr. Harris be allowed to check those?
Absolutely.
Thank you.
All right, Mr. Douglas, you had something else you wanted to address the court on?
Yes, I do,
And
Your
why
Honor.
don't we just right now set an agenda for the things we need to cover this afternoon? What are the matters you think we need to resolve
Your
this
Honor, we have to
afternoon?
resolve the question of the rebuttal list that we were given today. I would like to speak concerning the lay witnesses, Mr. Neufeld, about the scientific witnesses and the problems attendant to each. We have the matter to discuss in terms of our motion to limit the proper scope of rebuttal. As a corollary to both of those motions is the broader question of the discovery or lack thereof, and what impact, if any, it will have on our ability to begin the rebuttal case on Monday.
All right, Ms. Clark, this morning I saw a list of rebuttal witnesses go flying across my desk,
Right.
correct? Who do you anticipate as your witnesses for Monday, Tuesday, and Wednesday?
I didn't bring down any of the rebuttal list on, because I went flying down with the exhibit, so.
All right, I think some of that belongs to the court.
Yes, I know, it doesn't.
All right.
I need to get a copy of my stuff. I can tell the court and counsel that we intend to begin with the glove photographs. So it will be all of those photographers in addition to a representative of NBC or a stipulation to NBC video clips of the defending gloves.
Are we going to see Mr. Rubin again
Yes, we are.
after this?
Yes, at the conclusion of it all. And all of the photographs that we intend to present have been examined by him and authenticated by him already.
Okay, have the photographs all been given to the defense?
Yes.
Now, there are other photographs we've been told we're to get. I was just handed photographs that you ordered turned over a week ago that are the key ones that I've been told that they will probably use. We just got them. And I've asked every single day for them, and now I get them this afternoon, Friday afternoon. I can't send them out across the country. They're not going to. This is completely impossible for us to try and prepare for Mr. Rubin on Monday when we get these pictures on Friday. And we have the whole scope argument as well.
You know, I'm at a loss here. I'm not the one who did the discovery of the glove photo, so I can't respond to counsel. I don't know. As I understood it, everything went over to the defense.
All right, why don't we do this? Let's do this. As far as this issue is concerned, get your stuff, get Mr. Hodgman and Mr. Yokelson down here. Let's resolve the discovery issues for the rebuttal case this afternoon. I want to launch into, I want to give Mr. Regwan and Mr. Schwartz their hearing regarding the Furman tapes, and I take it, I don't believe either of you have any further interest in that particular aspect, do you?
Other than to indicate to the court, can I indicate to the court our position now, and then I can go upstairs and get to work on the discovery?
Sure.
Our position is that the tape should be released, and we urge that there be a full public viewing and hearing of all of the matters contained on them for further examination and review.
All right. Mr. Douglas?
Your Honor, we would defer to the position taken by Mrs. Regwan and Schwartz. We feel they are in the best position to assess and to comment on the admissibility or the release of those documents.
All right.
But, Your Honor, respectfully, I'd like to get back to work, particularly given some of the things that have been said just now. And if the court can indulge us, I would like to resolve these discovery matters before we launch into the other things so that we can get out of here.
Well, counsel, here's the problem. I need to clear off all of the exhibits I got here. I need to give them back to Mrs. Robertson so she can sort through what's been admitted, what's been kept out, and then she has to pull out those things I need to reconsider, or once I get the transcript. So I need to take some time with my staff to accomplish this. In the meantime, I thought I would at least give, because we had scheduled this matter at 2 o'clock. We're already an hour behind schedule because I did not anticipate this hearing today. We have the city attorney, Mr. Hahn, here, so I'd like to at least hear that argument, and I propose to limit it to half an hour. That'll give Ms. Clark enough time to track down Mr. Hodgman, Mr. Yokelson, get down here, let's settle these discovery matters. I am concerned about the photographs of the gloves because I did order those turned over last week, or earlier this week, whenever it was.
And, Your Honor, as part of that direction, can you ask that they be prepared to inform us of the next 3 days of witnesses and the order?
She's just given me, Ms. Clark just gave me glove photo persons, NBC video persons, and Mr. Rubin.
I don't think that's 3 days, though.
Probably not.
I wouldn't think, but who knows about process.
All right. Why don't you get started on that?
Okay.
All right, we'll take 5 minutes. I don't want to clear the courtroom, Deputy Jix. I just want to take 5 minutes to clear the exhibits off the bench. So, the production of certain audio tapes and transcriptions of those audio tapes that we have come to refer to as the quote-unquote Furman tapes. Those tapes, the originals and the transcript, and a transcript prepared by the District Attorney's Office, and a transcript, partial transcripts that have been prepared by the defense, are in the possession of the court. The tapes in a redacted copied form were considered by this court with regard to the use and admissibility of those tapes as they pertain to the testimony of Ms. McKinney. The unredacted tapes were listened to and the transcripts were read by another court as to another issue in Department 123, the Honorable John Reed. So those matters have been completely and fully examined by the court for purposes of rulings in this case. The party which produced those documents, Laura Hart McKinney, represented by counsel, has had, at the time that these tapes and transcripts were produced in court, asked for the protection of this court, asked for the assistance of this court in the form of a protective order so that these materials would not be disseminated beyond the confines of the real parties and interests, the prosecution and the defense and the court, for the legitimate purposes that those items were originally sought. We have now, because of the overwhelming public interest in these matters, been requested by various parties, the Los Angeles City Attorney's Office, representing, I believe, the Los Angeles Police Commission, and the American Civil Liberties Union, amongst other parties, have requested that the court make these materials available to the public without any further restrictions. I'll hear first from counsel for Ms. McKinney, and counsel, I'll also allow you to conclude the argument.
Thank you.
All right, Mr. Schwartz, good afternoon, sir. And I would like to conclude this part of the oral presentation by 3:30-ish.
Okay. Thank you, Your Honor. Good afternoon. May it please the court. 10 years ago, Laura Hart McKinney began a fact-finding expedition for the purposes of gathering information to be used in a screenplay to be made into a motion picture and in a novel. She worked for 10 years on these projects, and she recently completed the screenplay, and the novel is nearly complete. These end products represent the fruits of 10 years' worth of intense physical and creative labor. And the reason why we're here today, Your Honor, is to determine who should control the custody and the use of these materials. Is it going to be the exclusive and proper owner of these materials, or is it going to be the city entities, or will it be a special interest group that has its own agenda? We're opposing all these motions, Your Honor, for 5 reasons. The first ground for our opposition is the fact that the moving parties don't have standing to seek the relief they have requested. The second basis for opposition is that the relief requested would violate my client's rights as protected under the Copyright Act of 1976. The third basis for opposition is based on my client's privileges that are provided for in the California Constitution, Article 1, Section 2, namely the Shield Law. The fourth basis for opposition is that the relief requested would result in an unconstitutional taking in violation of my client's Fifth Amendment rights, specifically with regard to the Just Compensation Clause of the United States Constitution made applicable to the states by the 14th Amendment. And finally, the last basis for our opposition is more of a factual argument than a legal argument, and that is to say that the interests to be served by the relief requested have already been served by the cooperation of my client as rendered previously. So that said, I'll now address our first ground for opposition, standing. According to Yancey versus American Savings and Loan Association, California law is in accordance with the federal law of standing and treating standing as a jurisdictional requirement. Valley Forge versus Americans United is a seminal case on standing, holds that the doctrine of standing requires a party seeking to invoke the court's authority to show that they have personally suffered an actual or threatened injury as a result of the conduct of the defendant. Now, first of all, my client is not a defendant in this action. She is a non-party witness who was brought here against her will by a subpoena, as the court noted previously. And she has not engaged in any conduct that would ultimately threaten injury or actually cause injury to any of the moving parties. And therefore, the moving parties are unable to show any basis for standing according to the Valley Forge Authority. And with specific respect to the ACLU as a moving party, The Sierra Club case, another seminal case, Sierra Club versus Morton, provides specific guidance. It says standing does not exist merely because a party claims to be acting as a representative of the public interest, nor will standing be established by way of an organizational interest in the problem. And yet that's exactly why the ACLU is here. They say that they're representing the public interest, but that's exactly the kind of abuse that Sierra Club was decided to protect against. And so they have two reasons why they shouldn't have standing. And I know the court has granted the ACLU the right to submit motions previously, but that perhaps standing wasn't challenged in those cases, but we're challenging their standing to make this motion today. The second basis for opposition is copyright law. The moving parties have suggested that my client doesn't have a copyright interest in the audio tapes and the corresponding transcripts. And they proffer to this court the authority known as Estate of Hemingway versus Random House, which is a New York State case, persuasive authority, if it's even an authority at all, which was decided in 1968.
Predates the 76 Copyright Act.
Precisely. And so when they say that there's no statutory basis for a copyright protection in an audio tape, and there's only common law copyright interest, they're wrong. That authority is obsolete. Specifically, the Copyright Act of 1976 in Section 102A7 provides that sound recordings qualify for copyright protection. It says works of authorship include ... sound recordings. And in Section 101 of the Copyright Act, it says that sound recordings are defined as, quote, works that result from the fixation of a series of musical, spoken, or other sounds, regardless of the nature of the material objects, such as discs, tapes, or other phonorecords in which they are embodied. And so clearly, when my client affixed Mr. Furman's vocal sounds into a tape recording, she acquired a copyright interest immediately in the recording. And they've also hinted that just because Mark Furman has answered certain questions...
materials. Otherwise, the public's always going to say, did you get everything that was on these tapes? Did you investigate everything that was on these tapes? Is there a possibility that you may have missed some information that could have led to a criminal investigation or led to investigations that would have implicated other police officers? What are you trying to cover up? What have you missed? We need to reassure the public that we've done everything possible to get to the bottom of these outrageous statements. The public needs to be convinced that the police department is serious, that we want to eliminate racism in the department, we want to eliminate misconduct in the police department, we will not tolerate it. In order to do that, we need to do a thorough investigation. Obviously, the court is concerned about these property interests, but think of it as in any other situation. If the court came into possession of evidence of a crime or criminal misconduct, obviously, the police department would have the right to come to the court and say, we need that material, Your Honor. We need the court to turn that material over to us so that we can do a proper investigation. The fact that this is intellectual property doesn't change what it is when you come right down to it. It is evidence of possible police misconduct and possible criminal activity. Under those circumstances, the police commission has not only the right, but the duty to get those materials and investigate these charges fully.
All right, Mr. Hahn, does the police commission have independent subpoena power?
Yes.
All right, have you attempted to subpoena these matters?
Yes. We have served Ms. McKinney with a subpoena from the police commission for these materials.
All right, and when is that set for adjudication?
It's set for adjudication September 12th. She's been ordered to appear before the police commission on September 12th. We've been informed by Ms. McKinney's lawyers that they intend to file a motion to quash.
All right. Thank you, counsel. Mr. Morrell.
Good afternoon, Your Honor. Douglas Morrell, M-I-R-E-L-L, representing the ACLU Foundation of Southern California. With me in court today is, among others, the legal director of the ACLU Foundation, Mark Rosenbaum. Your Honor, I am mindful of the court's timing, and I realize that this is a collateral matter. And
it's been a long week.
I know it has. I appreciate that, Your Honor, and I don't really intend at all to make it any longer than it absolutely has to be. But there are obviously several issues that I want to be sure that the court understands and that I have an opportunity to address. First, let me just say what are the parameters of what it is that we're seeking. We are seeking access on behalf of the general public and the press, and by the way, I should note that Ms. Sager is here as well, and she may wish to address these issues briefly with the court. We are seeking access to the transcripts and tapes that were presented to the court. and were considered by the court, and which are the subject of the court's order of August 31st. We are also seeking access to all submissions that were related to the defense's proffer, as well, including the submissions by Ms. McKinney's attorneys, if any, by the city attorney, by Mr. Munger. All of that is by way of fulfilling what we think is a fundamental right, which is the right to ensure that the public has access to all aspects of what is a public trial. And these documents, like many of the documents we've talked to the court about before, including the transcripts of the juror dismissal hearings, these transcripts are every bit as much public records of a public trial and are public property in every bit as much a way as anything else that we've ever addressed with the court. I want to apologize first, Your Honor, for not having any written response to the papers that were submitted at the very end of the day yesterday and that we did not see until after the close of business yesterday. To the extent that the court has any lingering concerns that we can address in writing, I'd be happy to do so, work on it over the weekend, get you something on Monday. But let me address first some of the very crucial, important issues that are totally ignored in the opposition papers that arrived yesterday. First and foremost, the public record character of these transcripts and tapes. Ms. McKinney's opposition, I think, is notable for its failure to address, much less contest, the clear and unrefuted line of U.S. Supreme Court authorities that we have provided to this court that indisputably provide that public records that records of a trial are public records, that their sealing is presumptively unconstitutional, and that their non-disclosure can only be justified where it is essential, and those words are within the court's opinions, essential to preserve higher values and is narrowly tailored to serve that interest. Nowhere in their briefing are those cases addressed. Nowhere is this issue directly confronted. And I think I know why. The answer is that they have no argument in refutation to the concept that evidence that is presented to the court, that is considered by the court in reaching adjudications that have already been made, is evidence that is public information, and the public has a right to it, just as they have a right to attend this trial, just as they have a right to participate in the process of determining whether or not what is going on here is an appropriate exercise of the court's power, is an appropriate fulfillment of the rights, duties, obligations of all parties. Next, second issue that's unaddressed. The transcripts and the tapes in this case provide vital context to the defense's proffered excerpts and to the court's ultimate ruling on that proffer. Now, the reason why this central issue is unaddressed is also easy to understand. It's fatal to Ms. McKinney's arguments. As the court will recall, we initially made our request for access to these transcripts and tapes by means of an amicus brief filed before the August 31st ruling. But in that August 31st ruling, which followed many hours of argument and a 2-day hiatus in trial testimony, this court made clear that its decision was tied inextricably to not only the submissions of counsel, but also to the overall text and context of the Furman transcripts, and in addition to the tenor and tone of the Furman tapes. How do I know that? I know that from the opening paragraph of this court's order, where the court said that it had, quote, listened to the redacted audio tapes, read and considered the multiple transcripts of the redacted audio tapes. Indeed, Your Honor, in making the court's ruling, the order that was issued was so made clear that the court had been so careful in scrutinizing and comparing the transcripts and tapes that it made the observation, in line with the substantial inaccuracies comment that was made here in open court on the 29th, in footnote 4 of the court's order, the court said, quote, the court's comparison of the tape recordings with the transcripts prepared by McKinney revealed significant errors and omissions, despite Ms. McKinney's testimony that her transcripts were verbatim in nature. So we know from that the court did, in fact, not only read the transcripts, but actually listen and compare.
That's what I get paid to do.
I understand, Your Honor, and that's exactly why the public ought to be let in on what is going on and what it is that you had available to you when you issued your ruling. The reason why that's important is that any fair reading of the totality of this court's August 31st order, which was, in fact, very detailed, reflects a significant underlying focus upon the question of whether Mr. Furman was speaking as himself or assuming the role of a character in a fictional work. In particular, one of the specifically articulated reasons for denying the defense motion with respect to at least 2 of the incidents of alleged misconduct which were ruled inadmissible was, and this is a quote from at least one of them, "This is clearly an instance of suggesting a scenario for the screenplay." That's found in incident number 1. Similar language is found in the court's description of incident number 2. Similar fictional concerns obviously arose from the court's comprehensive contextual scrutiny that were identified with respect to at least 5 other incidents, incident 1, 9, 14, 15, and 16. The fact, Your Honor, of the pre-existing disclosures and exposure of these tapes, I think highlights what Ms. McKinney's true goal is, and that is to make her attorneys into the gatekeepers of the public interest, whose exercise of discretion will be unreviewable. We join with the comments made by the city attorney, Mr. Hahn. We believe that there is no reason why the kindness of strangers ought to be the test that determines whether or not the public or the police commission or anyone else has access to evidence which is actually before the court. Neither kindness nor sufferance are the test. The test is whether or not these are in fact public records that were considered by the court in the context of a public proceeding. Your Honor, let me address a couple of other issues briefly, and that is the following. I believe, Your Honor, that it's the height of naivete to believe that leakage, whether from Ms. McKinney or anyone else, or that leakage will not continue unabated. And I think that what we can be assured of, if this material is not publicly released, is that all of this information will come out, but it will come out in selective leaks. It will come out in dribs and drabs, and it will be pouring oil on the fires of this public controversy. And there's no reason for it, Your Honor. There's no reason for it because we can put an end to this controversy now. By releasing this material publicly, what we will do is we will accomplish 2 things. First, we will ensure that the public does understand what the basis of the court's ruling was. Second, what we will do is we will make sure that the public has access to this very important information. And why is that significant? It is significant, of course, in and of itself, because these tapes, as the court knows, have become somewhat of a cause célèbre in this city. And the impact of releasing this material and the impact on the public and the press is going to be magnified, in our view, if these tapes are not released at once, and if these tapes instead are released selectively, leak by leak. And we know it will happen because the court doesn't have access to the McKinney manuscript, the Men Against Women manuscript. Yet, I read in this week's issue of Newsweek that Newsweek has it, and they discussed it. That was the supposed intellectual property that was truly the subject of protection. But in any event, Your Honor, we know that to a moral certainty that this information will come out sooner or later, and there's no reason why it shouldn't happen sooner, because a third purpose that will be served is to ensure that the public has confidence in the very investigation that Mr. Hahn's office will be conducting, and that we have every confidence they will conduct in a fair, full, complete, and forthright manner. But unless the public has access to the information that the police commission has access to with respect to these tapes, there will be lingering questions about the fairness, the fullness, the accuracy, the completeness of that investigation. And that shouldn't happen. There's no reason why that needs to occur. Your Honor, I don't know what the court's concerns are with respect to standing, but let me just say one thing. Standing has been an issue that we addressed at the very outset. I stood here on August 31st, 1994, to address an issue before the court, which at that time was considering imposing a gag order upon the attorneys and imposing a sealing order upon the documents in this case. At that point, we brought to the court's attention Code of Civil Procedure, Section 526A, which provides for taxpayer standing. And if this court has any concerns about a corporation having taxpayer standing, although we clearly pay taxes within this county, I have a letter from Representative Maxine Waters, who sent a letter to the court on September 1st, a letter from her dated today, indicating that she has authorized the ACLU Foundation to represent her interests as a tax-paying citizen of Los Angeles County in seeking access to these materials from the general public. And I can provide a copy of Ms. Waters' authorization letter to the court and to counsel. But beyond that, Your Honor, 526A, taxpayer standing, is clear. We know what that's about. White versus Davis, this 1975 California Supreme Court case, says, quote, no special showing of injury to the particular taxpayer, close quote, need be made, and that the primary purpose of the section is to, quote, enable a large body of the citizenry to challenge government action which would otherwise go unchallenged in the courts because of the standing requirement, close quote. For that reason, as well as for the fact that Article 1, Section 29 of our California Constitution provides that the people of this state have a right to a public trial, in addition to the right that's possessed by the defendant under Section 15. That is a second reason, a second basis for bringing this action. We are enforcing a public right. And, Your Honor, even the case that was cited by Mr. McKinney's, in Ms. McKinney's papers, the Dix versus Superior Court case, even though that case was, in fact, vacated by the California Supreme Court on May 31, 1990, and rendered uncitable, a violation of the rules of court and the Business and Professions Code, even that case said that, well, I'm not going to talk about what that case said, Your Honor, because that case is not authority. But when the Supreme Court addressed this issue, all that it said is, look, when it was confronted with the victim of an aggravated assault seeking standing to challenge the trial court's decision to recall the defendant's sentence under Penal Code 1170D, the court said, look, private people have no right to step into the shoes of public prosecutors. And that's Hornbook law. Nobody's seeking to do that here. The sole responsibility of the public prosecutor is the sole responsibility of the public prosecutor. The court's issuance, though, of the protective order that was proposed by Mr. Schwartz and Mr. Regwan is an entirely collateral proceeding, and if there were a violation of it, we all know that it would be a violation that would be punishable through civil contempt, not criminal contempt. Your Honor, with respect to the other issues that have been raised, let me just say this, and then I will close. With respect to copyright, there are 2 points I want to make, but 2 very important ones. Ms. McKinney never asserts, nor could she, that an order rescinding the protective order that was entered or otherwise permitting the public and the press access to the Furman tapes and transcripts could conceivably constitute any act of copyright infringement. The court simply today lifted that protective order. It would have done nothing under anyone's definition in terms of having committed any infringement of any copyright. But, Your Honor, in addition to that overriding issue, which should be dispositive of any copyright concerns that this court has, in addition to that, the issue of whether or not these are appropriately works as to which Ms. McKinney can claim a copyright is solved by reference to the Copyright Act itself. And indeed, the relevant section is cited in the McKinney opposition papers. They say that copyright subsists, and this is the law, in original works of authorship fixed in a tangible medium. That's 17 U.S.C. 101. But the key word, Your Honor, is authorship. In this case, Ms. McKinney is in no way the author, for any copyright purposes, of Mr. Furman's answers to her questions. Now, Mr. Schwartz obviously recognizes this because in his papers he says, quote, Furman's notorious comments were intentionally elicited by the skillful and creative questioning of McKinney, close quote. Now, what that is an attempt to do is to argue that somehow these answers are the creation of Ms. McKinney. But that's wrong, Your Honor. And it's wrong because in 1884, the United States Supreme Court defined authorship for copyright purposes, and this is a definition which continues to subsist. The authorship provisions have never changed, and authorship is a requirement of the Constitution in order to obtain copyright protection. Authorship means, in the words of Burrough-Giles' lithographic, quote, "He to whom anything owes its origin, the originator, the maker." And here, the fact that Ms. McKinney may have fixed, for copyright purposes, may have fixed Mr. Furman's words in a tangible medium of expression does nothing to transmute her into an author of those statements. Indeed, the Nimmer Treatise, the leading treatise on copyright law, says, important as fixation is, we have just seen that originality is the essence of authorship. Accordingly, the originator, rather than the fixer, should be deemed the author. For the distinction between one poet who brandishes a quill or word processor and another who dictates to a stenographer cannot call for a differing legal conclusion as to authorship. And that's what happened here. Ms. McKinney may have an interest, a copyright interest, ignoring the Hemingway issue for a moment. Ms. McKinney may have an interest in her words and her questions. She doesn't have an interest in Mr. Furman's answers. And it's obviously the answers of Detective Furman which are the most critical key component of this issue. Your Honor, I'm not going to address the shield law issue. The shield law was ably addressed by Mr. Hahn. I associate myself with his remarks. The shield law goes to disclosure. It doesn't go to use. The shield law issue was waived. The shield law issue was dealt with in North Carolina, disposed of. I'm not going to deal with it here. Local Rule 719 compels this court to view protective orders like the one that was sought by Ms. McKinney with intense scrutiny. They are disfavored by this court. They are rightly disfavored by this court. The court must have found, or must find in order to preserve this, that secrecy is in the public interest, that Ms. McKinney has cognizable interests, and that serious harm will result from public disclosure. Your Honor, we believe that on all three of those points the answer is the converse. The eminent domain argument, Your Honor, is a ludicrous argument, I must confess. I honestly cannot believe that it was made with a straight face, but it mischaracterizes disclosure as eminent domain. It is not. The government's exercise of power to transfer property from an owner to itself is what's involved in eminent domain. This isn't McKinney's intellectual property, and even if it were, the formal appropriation of property by transfer of a title to the government has never happened, and I'm sure never will. This isn't even a regulatory taking, Your Honor. This is, and the case that's cited, I'm amazed, the Pruneyard case, is a case which, as the court may know, is a case in which the United States Supreme Court said that there was no taking when owners of private shopping centers are made to permit leafleters, picketers, pamphleteers, petitioners to use their facilities in order to get their expressive message out. So, Your Honor, on none of the points that have been made is there a viable argument here for keeping these materials secret, for keeping, and in point of fact, for permitting counsel for Ms. McKinney to decide selectively when the evidence that is rightly before this court will be disseminated to the public. And we would respectfully request the court for an order that does release these materials to the public and the press. And once again, Your Honor, as always, I appreciate the court's indulgence.
All right, thank you. Mr. Douglas, you had a brief comment you wanted to make.
If I may briefly, Your Honor. Your Honor, with all due respect, I've been very heartened and appreciative of the comments of all counsel, of Mr. Schwartz on behalf of his client. Respectfully, however, we now take the position, after hearing all the arguments, that given the unprecedented public interest in these tapes, as well as the importance in a full hearing of the larger community and societal issues which the tapes have raised, we believe, Your Honor, that justice is best served through the release of these tapes. We're very mindful, of course, of the interest that Mr. Schwartz has suggested. We're also very mindful, however, of what we feel on balance is the overriding public interest, particularly in some of the issues that were raised by Mr. Hahn. I think that it's very important that there be the ability to fully analyze and consider some of the very disturbing comments and implications that were raised. I've had occasion to listen to all 14 hours of the tapes and transcripts, so I have some firsthand knowledge of that which was not included in the excerpts. It is, in fact, very disturbing. There are, in fact, implications that go beyond the four corners of this particular case, and on balance, respectfully, we think that the interests are better served by the release of the tapes.
All right, thank you, counsel. All right, I need to take a recess at this point for the court reporter. We'll stand in recess for 15.
Your Honor, if I may ask the clerk to recess, I'd like to talk to you.
I think we've heard enough, counsel. Thank you. Stand. Yes. Ms. Schwartz, you have 10 minutes to respond. Also, if you would, slow it down a little, please.
Thank you, Your Honor. First, I'd like to address what I consider to be an unprofessional swipe at me. Mr. Morrell said that I cited the Dix case against the Business and Professions Code. The Dix case was vacated on other grounds, and I cited dicta which represents the law as it is today. And I'd like to read that portion that I cited in my brief. A person who is not a party to a criminal action has no standing to appear in the action unless a right in such party has been constitutionally or statutorily created. That's the law as it is today, and I just cited from dicta from that case. Now, Mr. Morrell also said that I didn't address the issue of what happens when something becomes a part of the public record. But I did in my moving papers. He apparently missed it. It's on page 20. I cited the case called In re Alexander. Case is persuasive authority that reasoned that while the public has a right of access to pleadings, docket entries, orders, etc., this right does not extend to information gathered in the discovery process not made a part of the public record. So the issue is, what portions of my client's materials have been made a part of the public record? Arguably, only the defendant's proffer that has been read into the record. That's only 5% of my client's material. There's other material that has been acquired in the discovery process but has not been read into the record, has not been made a part of the public record. In fact, it was protected by a protective order, and properly so. And so the public doesn't have a right to this. And we heard a lot of passionate arguments about what the public has a right to. They have to know, they have to know. But what authority has anybody cited saying they have the right to know what's in my client's proprietary materials? I haven't heard that. The public wants to know a lot of things. The public wants to know who shot John F. Kennedy, but they're not entitled to know that yet. The public wants to know the name of rape victims in several cases, but they don't know that. The public probably wants to know what transpired in private conversations on the defense's side of the table, and they probably want to know what transpired in private conversations on the prosecution's side of the table. And even though the prosecution represents the people will never find out what transpired in those conversations. They can't know. There are sealed proceedings that, in this case, that the people will never find out about because they're sealed. And this is just another example of another thing that the public does not have a right to know, my client's proprietary property. And if you take the ACLU's argument to its logical extreme, they can come in here with their taxpayer status for standing and argue that the public has a right to know how Mrs. McKinney decorates her home, and so they can just march into her house and start taking pictures off the wall because the public has a right to know. That's absurd, yet that's what they're trying to do with my client's proprietary information, in which she does enjoy copyright protection. And this seems to me to be the tyranny of majority. Everybody's coming in here clamoring that they have the right to know, and based on that, because everybody's in agreement, my client has to forfeit 10 years' worth of intense creative labor. And the other argument that the ACLU put forth, which is kind of ridiculous, is this idea that it's going to leak anyway. This leakage is going to happen. We all know it, so why don't we just get it over with and turn over the whole thing? Well, I guess if somebody's dying of cancer, we should just shoot them in the head since they're going to die anyway. I mean, forget about trying to cure cancer. And of course, they're saying that by lifting the copyright, by lifting the protective order, the court would not be engendering a copyright infringement. But really what the court would be doing is putting my client's information on a silver platter and ringing the dinner bell for everybody else in the world to attack it and distribute it and reproduce it in whatever form they so desire. And if I may just come up with a creative metaphor to illustrate the point, if I were to take a rabbit by the ears and drop it in a rattlesnake tank and turn around and say, well, I didn't kill the rabbit, the snakes killed the rabbit, we all know that would be wrong because I killed the rabbit by dropping it into the tank. And by lifting the protective order, the court would effectively be killing the rabbit because they're putting it out there for everybody to attack and to use without my client's permission. And let's talk about Mr. Furman's words for a second. they're still claiming that my client doesn't have a right to those words. Well, she doesn't have a right to his words, but she has a right to the sounds that she transfixed into this medium of expression called an audio tape. She does have a right to that. And although we fervently contend that Mr. Furman does not have a right in his answers that were recorded on tape, I'd like to point out that Mr. Furman entered into a contract with my client where he would get $10,000 in exchange for doing all this, and so he forfeited whatever rights he had in favor of my client. And they said that my eminent domain argument was ridiculous. But if this court sees fit to completely devalue my client's property by setting it up on this silver platter, of course that's a taking. And to the extent that the ACLU says it's not a taking, we know now what ACLU really stands for. Another constitutional law undermined. And let's talk about authorship for a second. Let's take two famous cases of authorship. Abraham Zapruder caught the Kennedy assassination on film. Fortuitously, he was standing on a hill and he filmed the assassination. He caught that on film. Now, he doesn't have a right to stop people from reenacting the assassination, but he certainly has a right to that film, and he sold it to Time magazine. And George Halliday, when he videotaped the Rodney King beating, he didn't participate in the beatings himself. He didn't tell the police what to do. He just ran outside and taped it. And he has a copyright in his videotape. And now with the Furman tapes, my client, unlike the Halliday case and unlike Abraham Zapruder, my client overtly participated in that conversation. Mr. Furman would not have uttered those words if it wasn't for my client's questions. She actively participated in that and skillfully elicited that information and recorded it. And the recording is where you have authorship. It's not the fact that he said it, it's that she caught it on tape. And she is an author simply by virtue of the fact that she flipped on her tape recorder. If I took a picture of this courtroom, I would have a copyright in that picture.
Slow down.
And likewise, when she started her tape recorder, a copyright interest was created immediately therein. I'll address the city's argument for standing. They may have a standing because they need to conduct this investigation, but the question is, do they have standing in this proceeding? And they don't. And in fact, no charges have been filed against anybody. And if they need information for an investigation, for charges, then I understand that. But still, they need to go to a grand jury and get an indictment or something. No charges were filed based on the Furman tapes. And they need to initiate their own proceeding. And they do have subpoena power in another action. And we'll handle it, and we'll take it up at that proceeding. And they've actually served that subpoena. So they don't need this court to do that in. I think that they're trying to use this court because we otherwise might be able to raise the shield law, which Mr. Simpson could overcome, but they can't overcome that. And we contend that we haven't waived any protections afforded by the shield law because of the protective order. The information was used as far as it was needed for the Simpson case, but to the extent it could be used for something outside this case and unrelated to this case, for example, an investigation, she is still entitled to invoke that shield law. The city says that it would pose an administrative burden on them if they were to have to continually come back to our office to conduct their meaningful investigation. But I'm aware of no authority which purports to be a law of convenience, allowing a governmental entity to subjugate the property rights of my client, just so they can make life easier on their employees. My client has property rights that have to be respected, and we're sorry that it may cause an inconvenience to anybody, but that inconvenience doesn't give them the right to come in and demand wholesale copies of my client's materials. And they argue that it wouldn't be a copyright infringement for the city to have these materials because they're not going to be distributing them and they're not going to be reproducing them, but it would be a copyright infringement for the court to give a copy to them because that infringes on my client's right to distribution. Even if it's just one copy to one person. My client has the right to do that. The court doesn't have the right to do that. The court has the absolute right to use my client's copies of her work for these proceedings as it has ably done. But for matters that are outside the scope of this proceeding, the court has no authority to start giving copies of my client's work to anybody who comes in here and demands them. Also, I don't know how much more of an investigation with regard to my client's tapes is necessary for the city. I mean, they've already heard everything that's on there. They pretty much got the gist of it. As I said before, they're welcome to come back. But a meaningful investigation can be accomplished at this point by using that information now. Go ask Mr. Furman some questions. Go ask the victims of these alleged incidents of police misconduct. Open Mr. Furman's files, which I understand are sealed and sent off to Sacramento. I mean, there's a lot of things that they can do now for that investigation. They don't need my tapes anymore, my client's tapes anymore. They can use that information that they've already garnered. If they need to come back, they continue to look at it. That's fine. But they can show the public that they've already started their investigation. We will continue to help because we realize this is an important thing. And then they can start with the rest of their investigation. They don't need to have a copy of my client's materials. And unless the court wants me to address any other issue, then I would again just pray that the court respect the protective order, which was properly enacted. I guess if I may, I'll just address why the court's protective order was proper.
Well, I think you can assume that would be a persuasive argument since I issued it in the first place.
Okay? The local rule was brought up by the ACLU 7.19 saying that we haven't satisfied 3 requirements for the protective order. The first requirement is that secrecy is in the public interest. Second requirement is that my client would have to have a cognizable interest in the materials. And third, that serious harm would result from a public disclosure. Secrecy is in the public interest, Your Honor, because to protect these materials would protect the reasoning behind the copyright law in toto and the Shield law. Because for the copyright law was enacted to give authors a monopoly on their work, to give them an incentive to keep creating. That's why we grant it. And if we don't respect that monopoly, if we don't respect that protection, then the public's interest in promoting the arts and sciences will be derogated. We want to protect this copyright so that we can send a message to all other authors that, hey, you will be protected if you create your works. The second factor, that my client has a cognizable interest in the materials. I mean, even the ACLU would all but concede that at least my client has a right to her spoken words. And that's about half of what's on the tapes. And this tape recording, or these tape recordings, are not indivisible works. Excuse me, they aren't divisible works. It is an indivisible work. You cannot just go through there and redact one person's words. This is one unit, and my client owns it. And the third factor is that serious harm will result from a public disclosure, and serious harm would result from a public disclosure at this time without my client's permission. And that would be, of course, the complete devaluation of 10 years' worth of creative intent and physical labor. And for that reason, Your Honor, the court's issuance of the protective order was completely proper, and it should not be undermined at this point. And so again, unless the court wants me to address another issue that it is still considering, I would ask the court to uphold the protective order and to deny the motions of these non-parties.
All right. Thank you very much, counsel.
Thank you.
All right, let's shift gears. Counsel, I'm going to take the matter under submission. It's not a matter that I need to address immediately. I do need to get my rebuttal case underway, so you can anticipate a ruling sometime next week. All right, thank you, counsel.
Thank you, Your Honor.
All right, we have 3 issues before us with the counsel for the real parties and interests. The list of rebuttal witnesses, I do have before me a letter, 2 letters from the District Attorney's Office, both dated September the 8th. And the first letter, there is a list of 59 rebuttal witnesses.
Argue these issues with the court. I just returned to the courthouse. I've been gone all afternoon, but the letters that the court just indicated are most recent additions. I'll attempt to assist the court and Mr. Douglas the best I can.
All right, are Ms. Clark and Mr. Hodgman en route?
I'm trying to reach them, Your Honor.
You should find them.
All right, well, I mean, we've got, okay, well, you've got the list of potential witnesses. Mr. Darden, do you have any information as to, my understanding is you're going to start with certain photographers who've allegedly taken photographs of Mr. Simpson in the wintertime wearing gloves?
That is a probability.
Your Honor, if, I heard the court say, I know Ms. Clark anticipates arguing the rebuttal of the glove evidence that we just said.
Though I'm just trying to figure out who the next several witnesses are going to be. But how about if you get them down here?
I'm trying, Your Honor.
All right.
Perhaps Mr. Darden can talk about the 59 names since he signed that letter.
Well, I assume that since they've told both myself and the jury that they have approximately 5 days worth of presentations, that this is a list of potential witnesses given how things go. For example, Bruce Weir.
Well, of course, we may need him for additional numbers, so that's why it's on the list.
As you know, there's a serious issue with respect to the
Scientific.
RFLP results from the Bronco, whether that comes in on the rebuttal case that we have to address today. And I submit to you that Dr. Weir absolutely would be necessary if they're going to be allowed to put that in. And then Dr. Shields is going to be a witness in rebuttal, and Mr. Sims is necessary for it. And I think that there's a serious issue there as to whether or not they can present that at all.
All right.
That we have to address.
All right. Record should reflect that we've now been rejoined by Ms. Clark and Mr. Hodgman and Mr. Yokelson.
If the court pleases, Your Honor, can I deal with the lay witness issue and then leave to Mr. Scheck the scientific witness issue?
Sure.
Or Mr. Neufeld?
Sure. Certainly.
My colleagues are prepared to answer the court's questions, Your Honor.
All right. Counsel, we anticipate beginning the prosecution rebuttal case Monday morning promptly, I hope. Who do you anticipate now that you've had some time to contemplate these matters and the other issues have been resolved by the Court of Appeal?
We need to, I believe that the court wanted to take a waiver from the defendant.
That'll
Correct?
take all of 30 seconds.
Okay. Are we going to do that today, or?
I would assume shortly before, out of the presence of the jury, but before we resume on Monday.
Okay. And then we intend, as I indicated to the court, to begin with the glove photos.
All right. Who are your glove photo witnesses?
And Mr. Hodgman has the list after that. Bella.
I'm sorry, could you just speak a little?
Gordon Bella. Karen Brown. James Chegia.
How do you spell that?
Chegia. Correct. Deborah Guidera. Mark Kruger.
Sorry, could you just spell those names?
Kruger is on the 27 on the witness list.
Mm-hmm. And Richard Rubin.
All right, the
William
first...
Rankin.
Rankin?
Yes, Your Honor.
What is this person's role?
William Rankin is another person with the glove photographs.
Do you intend on calling all of these photographers?
To lay the foundation, it's about 1 minute of questioning. Did you take this picture? Yes. When? That's it.
Where?
Where? And where? I mean, the total sum of all the photographers, the number of them is about 10. Their questioning will take about 5 minutes each, if that. And that's it. It's just a foundation for the picture.
All right.
Richard Romano. Richard Roman. Michael Romano. And I said Richard Rubin. Kevin Schott. Rob Seib, S-E-I-B. That's it. And an NBC representative.
All right. After you conclude with the glove photo witnesses, who do you anticipate using after that?
After that, we intend to call Gary Sims.
As to what issue?
That's the blood in the Bronco, the RFLP result on the console.
All right. And are you going to need to recall Dr. Weir?
We need to address the court on that matter.
And what is the status of the DOJ RFLP?
4 probes. There was a 4-probe match to Ron Goldman and the defendant.
As to each?
It's a mixture. I think it says to each. I'm not prepared to address that, Your Honor. That's going to be addressed to the court by Brian Kelberg. I
All
assumed
right.
it would be Monday.
I would suggest then that we set for a hearing Monday, probably at 5, because we have that issue of the timeliness of performing the RFLP that's been raised.
Okay.
All right.
We received another order read this afternoon, and the problem I have is that anticipating that we were promised a report from Mr. Bodziak, we haven't gotten it. I got a report yesterday from Mr. Popovich. Glove photographs were supposed to be turned over, haven't been turned over.
Counsel, let's take this up one item
All
at
I'm
a
saying
time.
is that I would prefer, and I don't see any reason why it shouldn't be done, that we address this now. I'm prepared to argue it. It was scheduled to be argued. It's not fair to dump all this discovery at the last minute on us. We're going to ask for adjournments. I'm telling you right now, we're going to ask for adjournments because they've been playing with it. They had this stuff.
All right,
They haven't been
counsel.
turning it over. If we can eliminate this
I've
and
heard
resolve
enough.
this issue.
I've heard enough.
Okay.
Thank you. All right, Sims, then probably who? Weir?
Well, depending on the court's ruling, that's what we're going to need to address with the court, as to whether Mr. Sims can be allowed to do the numbers. And then Brad Popovich. Now,
Popovich was who? Refresh my recollection.
Brad Popovich is
Oh, this is DNA, PCR lab stuff.
correct. Response to Gertie's.
All right, and then what topic are you going to move to after that?
Then we'll be seeking to admit the Thanoparatus video under 1202 of the Evidence Code.
The Paratus, okay. That should take all of about 5 minutes.
The Paratus video? Correct.
Yep.
Yeah, that's very brief.
Okay,
Right.
correct. But if you recollect, we had a long discussion about this.
Right, right. The Ackards, I think it was Lawrence Ackard and his wife,
As to what issue?
that goes to Robert Heidstra.
What's the wife's name?
Pardon?
What's the wife's name?
Heidstra.
The wife's name. She's not on the list.
wife's name.
Patricia Beret also goes to Robert Heidstra.
Is this the person in the pet shop?
I'm sorry, and Christian Anders. I'm sorry.
Was this the person in the pet shop? Or the
Yes, Your
pet
Honor.
hospital?
Yes, Your Honor.
Yeah,
All right, and who was the other person? After Beret?
Christian Anders.
Anders.
Right, and that's another witness who received a prior inconsistent statement from Robert Heidstra. Yeah, George Field, number 20, another Heidstra witness.
All right, where do we go after that?
After that, Dr. Don Dutton.
Dr. Don Dutton? As to what issue?
As to pre- and post-homicidal conduct of murdering spouses.
I sense a 402 hearing.
Yes, that may be so. He will be addressing the demeanor witnesses called by the defense, if the court recalls.
All right, if you would, put together your Ps and As on that,
On
both
Dutton.
sides. On Dutton.
Can I get an offer of what I'll testify to? I'll know how to address it, Your Honor.
Do you have a report from Mr. Dutton, or any works or a CV from Dr. Dutton?
I have a CV with any notes or anything.
The defense has his CV. With respect to his proposed testimony, we will be meeting with him tomorrow, and I will put together an outline of what he proposes to testify to.
Okay, off the top of your head, though, I mean, I'm sure you've had preliminary discussions where you've decided you may call him. Can you just give me a heads up as to where we're going with that?
Yes, what he has done, Your Honor, is he himself has done a study interviewing men who have murdered their wives and reviewed their cases to determine what their pre-offense behavior was, their demeanor, and their post-offense behavior was. And it goes to the issue of what one would expect to see in their demeanor.
Has Dr. Dutton been allowed to testify in any other courts with regards to this?
I don't know. I
With regard to this?
You know, I hate to make a representation to the court. My sense of it is that he had. He's certainly very well versed in the area as to what kind of behavior is to be expected, given his studies and his involvement in the field. But I need to get with Dr. Dutton tomorrow to make sure of that.
All right, I'll need to see P's and A's on this. Okay, what do we anticipate going after that?
You appreciate the difficulty in our ability to respond yet until we have a chance to understand more.
But I think the issue is pretty clear.
An additional area of inquiry of Dr. Dutton would be a victim's profile to debunk the myths.
And what's that rebutting, Your Honor?
And that goes to the testimony elicited by the defense from Ronald Simpson, Christian Reichardt. Who else? At least those two witnesses, though, concerning the behavior of Nicole Brown in the time before her murder, her conduct with the defendant. What the defense is going to argue, based on their testimony, Your Honor, is that there were no problems between them because, after all, she was still friendly with him, she was at the house with him, and she had nothing to fear from him. That is a myth that can be uniquely addressed by someone involved and an expert who is an expert in the field of domestic violence, as Dr. Dutton is. He will be able to discuss the fact that the typical battered spouse syndrome, or the battered spouse, doesn't necessarily run away and stay away from the spouse who is doing injury to her, of whom she is afraid. And that would go to address the issue specifically raised with Ronald Simpson's testimony that she saw Nicole sitting on his lap just weeks before the murder, and Christian Reichardt's testimony concerning the nature of their relationship on and off again, coming back to each other, leaving each other.
All right. Where do we go after Dr. Dutton?
And with respect to where we go with that after Dr. Dutton, Your Honor, we will be filing a brief with the court, and we are going to ask the court for the ability to bring in the evidence in the study prepared by Doug Diedrich concerning the rarity of the broncho fibers. We believe that the defense has opened the door to this in two ways. Number one, that in his questioning of Kathleen Bell, Mr. Bailey brought up elicited from her a description of the vehicle driven by Mark Furman, which was a pea green and white utility vehicle. There was no effort made by Mr. Bailey at any time to verify that that was indeed the vehicle Mark Furman drove at that time. I'm sure the proffer would be from him that he attempted to elicit that to show that she could identify Mark Furman, that she did know him, in order to impeach the testimony he gave that he did not remember her. However, without an effort made by the defense to tie that vehicle into Mark Furman, what the purpose of that was, and I bet the argument will be forthcoming, that he had a predilection for that kind of sports utility vehicle, similar to a Bronco. So that's one area in which I think. The other one is the general attack upon the credibility of Mark Furman. In that regard, it was the Bronco fiber that was found on the Rockingham glove. That goes to impeach, what that does go to reinforce the fact that it was not planted, that it was indeed tied to the defendant through the fiber from his car.
Okay, well, put your P's and A's together and but I'd like you to also include in your P's and A's cites to where it is in the transcript so I can
Yes,
find
we
it.
will.
Okay. All right, and then where do we go after Mr. Diedrich?
And Your Honor, this is all within 5 days?
Well, the photographers are going to go, I assume, very quickly.
Mr. Diedrich will address the fabric impression on the envelope to which Dr. Lee testified.
I'm sorry, is that Diedrich or Bozak?
Diedrich.
Fabric impression, that's on the, I'm sorry, on the...
I think it's on the envelope. My memory serves me it was on the envelope.
Okay.
Parallel lines that Dr. Lee testified to,
Okay.
which he thought might be consistent with a shoe print, but which we have determined, I think we have determined, we haven't gotten the report yet, to be consistent with, I believe, the genes of Ron Goldman. And Bill Bodziak to address the shoe prints testified to by Dr. Lee.
Okay. All right, well, that ought to take a couple of days. All right. Mr. Scheck and Mr. Douglas have raised certain discovery issues regarding these matters. And the most difficult, of course, being the scientific witness matters.
All right, may I make just one small suggestion first?
Certainly.
Which is that on this list of 60 witnesses, there are, since there's no indication whether someone is a PhD or an MD or an expert in any field, what we need to know for obvious reasons right now is who on this list of 60 people are intended to be experts. You've, of course, elicited from them several, but there may be many others. One person I see on the list, for instance, is a psychiatrist.
Saul Fairstein?
Yes, although it's not indicated here. What I would ask is, especially if it's the people's position that they intend to complete their rebuttal case in 5 days, given a list of 60 witnesses, and given the obvious limitations that we have in being able to prepare cross-examination of these 60 witnesses, and the special problems that arise when you're dealing with experts, notes, reports, 402 hearings, FRI hearings, and the like, at a minimum, Your Honor, today, so we don't waste a moment over the weekend, we would ask the court to find out from the people of the list of 60 who do they intend to elicit expert testimony from, And then as to those people, at least the proffer. So, because we, as Mr. Scheck was pointing out earlier, we need to know what's realistic so we don't go off on wild goose chases in the very short amount of period that we have to get ready for these witnesses.
And as to lay witnesses, Your Honor, we'd like names and addresses because some of these names are new to me.
What concerns, we're just really concerned with the suggestion that this is all going to happen within 5 days. And this list is inconsistent, frankly, with that representation. So at a minimum, Your Honor, right now we need that. We need to know who the experts are, and a very brief proffer, not an unextensive one, but just the kind of thumbnail sketch that you asked for so we can know where we stand.
All right.
I would just remind the court that this comes from the team that repeatedly gave us people on the short list who were never called, people that I have prepared for extensively who were never called, and I didn't find out that they were not going to be called until yesterday. So I just want the court to get a sense.
I have my own list of witnesses that we haven't seen, so
Right, okay.
I understand that. But
in order
But
to...
as you know from our conversation yesterday, Ms. Clark, my biggest concern is finishing this case with an intact jury. And delay is something that will be anathema next week.
I agree with you. I think all of us share that concern, Your Honor. There's no question about it. In order to avoid being precluded by failing to give notice, however, we felt it very important to be as inclusive as possible. We don't want to be caught short that way. With respect to who are the experts,
All right, let's go. Why don't we go down the list and let's identify who the experts are.
Michael Bodden.
All right.
Now, Michael Bodden would not be called for expert testimony. I think I should indicate that to the court. Michael Bodden, Saul Fierstein, obviously experts. They would be called for the events of June 17th.
What's the profit for that, if I may ask the court, Your Honor?
We're talking about the chase.
Recall there being any defense case witnesses that would have raised that issue so as to make this a proper...
Well, that's a scope issue. What we're going to do is identify experts.
Very well, Your Honor.
All right, we're not at the scope issue yet.
Yes.
Okay. Bodden and Fierstein, you were only offering for their non-expert observations of the events of June 17th.
That's right, Your Honor.
Okay. Bodziak is an expert.
Except, let me make one proviso on that. With respect to Dr. Fierstein, he will be able to tell us the effects of Xanax, which were found in the defendant's possession on June 17th.
All right. Doug, let's see, I have Mr. Bodziak as an expert.
And I've already informed the court what that's about.
All right. Douglas Diedrich,
And the court knows what that's about.
Peter DeForest.
And that's that goes to the socks.
Yes.
The court's aware.
I know who.
Well,
Mr.
Just to remind you, Your Honor, there's two issues on DeForest. One is that you're reviewing other material to see if it's Brady or exculpatory material. And two, although the people have made one representation that his testimony would be about socks, I just would like a thumbnail sketch proffer. What other topics is he going to be addressing? Not in detail, but what other topics, so we can look into
Well,
it.
let's go through here first and see if who the experts are,
Then go back.
and then we'll go back and see if there's anybody who's a mystery to you. All right, let's start at 20. George Field.
Okay. None of those are experts until we get down to Roger Leach.
All right, and who is Roger Leach?
And Roger Leach is an expert pertaining to the rarity of the rock and fiber.
Okay.
And let me indicate something to the court with that, in that regard, if I may. Roger Leach, and skipping over to the next page, I don't know if they're on yet, Norm Anderson and David Boyd. Okay, those three would all be called in expert capacity concerning it's the manufacturer of the fiber. Each one would be giving testimony of about 10 minutes in length, because all they're going to say is, for example, Roger Leach would go to the fact that the dye used for the carpet fiber that was identified by Doug Diedrich was used in this time frame by his company and put in and sold and put into these kind of cars. That's it. And with respect to Norm Anderson, this kind of carpet, this cross-section of carpet fiber was manufactured between these times, and that's it. So we're talking very, very limited testimony from these people.
All right, who else are your experts on your list? Brad Popovich.
Right, Brad Popovich.
How about Stephen Oppler?
Stephen Oppler is a DA investigator. He's just there to authenticate the Paratus video.
All right.
And Rich Rubin Galper as an expert, so was for examples. Gary Sims is already known. Chris here is known.
All right, what is your, I'm concerned about the presence of Leroy Taft.
Again, okay, with respect to, I'm sorry. Leroy Taft and Kathy Randa, I believe, are on the list because we intend to, as part of the events of June the 17th, present the fact that they, within minutes of Mr. Simpson's departure from Mr. Kardashian's house, went to the Union Bank, to his safe deposit box, and recovered large sums of cash in a briefcase. This all goes to part of the chase, which goes to consciousness of guilt. And we would ask leave of the court to file P's and A's on this issue for the admissibility of this testimony if that's in question.
I think it's a scope issue, wouldn't you say?
I understand. That's,
All right.
Your Honor, my understanding is that witness has recanted that version. So I think there's a foundational issue as well.
What?
Should talk to me again.
Okay, we've identified the experts. All right, Mr. Neufeld, and either you or Mr. Scheck, why don't you address your concerns regarding the status of our discovery issues?
Your Honor?
I'm sorry.
I'm sorry. I'm not the one who's privy to that information, and Rock Harmon is the one who is. Concerning the RFLP results, is that what you're...
No, I just mean all the expert witnesses. I'm just interested in what the status is regarding all of these people and all their reports, et cetera, et cetera. Speak of the devil.
There are also discovery issues as to the gloves.
Just as a procedural matter, would you prefer to deal with the discovery, or would you prefer...
No, I want to get the discovery issues out of the way first.
Before we deal with the scope of rebuttal?
Yes.
Okay.
Yes. I would rather have you preparing over the weekend. All right, Norm Anderson, number 5. That was as to, Norm Anderson is one of the fiber people, correct?
Right.
Do you have any reports from this person?
All of the information that they would testify to was turned over in the People's Case in Chief when this issue first arose.
All right. Michael Bodden, that is not being offered as an expert.
No.
Mr. Bodziak was one of the issues that came up before. You've turned over his notes, correct?
Yes.
Are there any other notes or reports?
Your Honor?
Yes.
May I point out that Mr. Goldberg indicated to me he was unaware of it, but as the court distinctly recalls, Mr. Hodgman and Mr. Yokelson represented to all of us that we were going to get a report from Mr. Bodziak. It's insufficient to simply say he's going to testify about shoe prints, because that's what he did on his testimony in the direct case. What is he going to testify to in rebuttal to Dr. Lee in regard to which exhibits, which scientific tests? In addition to that, it appears now from pictures that were given to us yesterday that the genes were, without notice to us, used in a fashion where it appears, Mr. Goldberg informs me, that we have a picture of Ron Raquel doing something or taking an impression of them, which was then sent out to the FBI. We weren't given any, I don't know if that could potentially be a destructive test. We weren't given any notice of that.
What kind of test was this?
I don't know. They were manipulating the imprints on the genes in some fashion, whether to take impressions of them or not, to send them to the FBI for purposes of testing. Now, what's quite aggravating is that as we are discussing the scope of all of this and what discovery should come over, and we're trying to find Mr. Goldberg to find out what dates contact sheets were turned over and the rest of it, they're off doing these things without giving any notice of potentially destructive tests, so we could have somebody present to see what they're doing and get some handle on this, and at least request permission to be present when any impressions or testings or comparisons were being conducted by the FBI. They're doing this now. Mr. Goldberg told me yesterday, and he can speak for himself on this point, that these fabric things were being sent to Mr. Diedrich and they were going to find out what the results were. I think he said that this morning. Now I'm finding out something this afternoon. There's nothing here. But I think it's really improper that they didn't give us any notice whatsoever that they were even going about doing this so we could have somebody present to make a record of it. And if it potentially was a destructive test. That's one thing. The second thing is, it's not enough to say that Mr. Bodziak's going to testify about shoe imprints. It's got to be directed towards what, if anything, he's going to say in rebuttal of Dr. Lee on what specific points of evidence, because he testified to the other stuff on the direct case. We've gotten nothing here, and they told us they were going to give us this a week from now. And it seems to me that there's a big double standard. They shouldn't be allowed to take advantage of the fact that we're all sick and tired of how long this is taking, and the jury is sick and tired, and we're all on edge. But the point is, I will not, on behalf of this client, permit this kind of situation where we're going to be ambushed. It will not happen. I will ask for an adjournment and take as long as it is need be to have the appropriate people look at this, and I protest the potential destructive tests on this evidence without notice to the defense.
Mr. Goldberg?
I thought it was the court that decided what was going to be allowed and not allowed, not Mr. Scheck, but maybe I'm mistaken about that. As to the test impressions, Your Honor, first of all, these test impressions are non-destructive. When Dr. Lee testified, I learned for the first time during his testimony that he had concluded that the shirt that was worn by Ronald Goldman, in his opinion, could not have created the impressions on Ronald Goldman's genes. He had previously told me in telephone conversations that we had had prior to his testimony that he believed that the genes did not create the impressions on the evidence envelope or the piece of paper. I assumed, I do not recall asking him, but I assumed, because it is a standard forensic practice, that Dr. Lee took test impressions from Ronald Goldman's genes and from his shirt. I was flabbergasted when I learned that that was not the case, and that he was testifying to an elimination without having made a test impression. When I spoke to Mr. Bodziak about this, he informed me that you have to take a test impression in that situation. I told him that in my opinion, it seemed to me that the genes could not have created the impressions on the envelope and the piece of paper, because I thought that just from my knowledge of lay knowledge of genes, if you press them down on a piece of paper, you'd get a flat impression, that you wouldn't get parallel lines. Well, I was incorrect in that assessment. And we have taken these test impressions, which is a non-destructive technique, in order to send them to the FBI, and did so immediately upon learning of this potential problem with Dr. Lee's testimony. So I don't see any basis for complaint here.
What is the medium used to take the impressions? I mean, do you press it into wax?
It's something called an identicator.
That's helpful.
What? Your Honor, I had never heard of it before, and it's a very nifty little device that we were sent by Mr. Bodziak that allows you to, well, for example, you can put your finger on it or any other object, and then you put your finger on a piece of chemically treated paper, and the print then appears on the chemically treated paper, and there is no noticeable residue left on your finger. So it's a nifty little gadget that...
Sounds like the kind of thing that
yeah.
one does with check
Well,
identifiers. Anyway, Mr. Scheck?
just looking at this picture that they gave us, it appears as though it left an impression on the blue jean. My point is, if he doesn't know whether it's non-destructive or not, whether it's going to change the imprint impressions on the blue jeans or not, it certainly was appropriate to notify the court that is the practice, that is the Griffin problem, that what was going on here. This is
addressing
wrong.
all of Mr. Scheck's issues. No, this is clearly, without any doubt, a non-destructive test. It's not even a test, it's just taking an impression. I mean, we all know what impressions are, and we took impressions, and I think we're entitled to do that without any question. And we wanted to do it as quickly and expeditiously as possible so that I could send these things out immediately. They arrived, I think, a couple of days ago at the FBI, and the analysis is underway. Obviously, we want the opportunity to be able to present this evidence. Now,
Who will be presenting that? Mr. Diedrich?
it's going to be a combination of Mr. Diedrich, probably mostly Mr. Diedrich, and perhaps Mr. Bodziak as well. Mr. Diedrich apparently has expertise in fabric impressions, and Mr. Bodziak has expertise in shoe impressions. So it's sort of a dual testimony that will be presented
So what
to
is
address
this?
this issue.
So, but this testing is still ongoing.
Well, I wouldn't call it testing, it's a comparison.
All right, do you have any results yet?
I don't have any results other than tentative results that have been relayed to me by Mr. Diedrich.
And what are those tentative results? What do they tell us?
That he thinks that, and I hesitate to repeat them because I may be misstating or oversimplifying what he told me, because he has not completed his analysis. And as the court knows, forensic experts usually don't give you much of anything until they're comfortable, they've reached a certain state of comfort with respect to their analysis. But reading in between the lines, my interpretation of what he was saying is that the marks on Ronald Goldman's jeans are consistent, or may turn out to be consistent, with the shirt, and that it does appear that the marks on the eyeglass envelope and the piece of paper are consistent with a Levi's blue jean. But as I said, he hasn't finished his analysis yet.
When do you
And I'd also remind the court that Mr. Lee obviously just testified about a week ago, and we did try to get on this very promptly in terms of taking the impressions and following up on this, and it was in relationship to Mr. Lee's testimony. And I will point out that that was not in any report or notes of Dr. Lee that he had excluded these two items. And the only reason that I knew about the jeans is because he had told me about that orally, and I learned about the shirt on the witness stand. And I didn't know that he didn't take test impressions from that until he testified on the witness stand. Now, as to the issue of reports, Your Honor, I agree with Mr. Scheck that there appears to be a double standard here that's being requested, because they have said over and over and over again that there is no duty to create reports. That is an argument that the court is very familiar with. And they have said that they have not asked their experts not to create reports, but that their experts simply don't create them. In this particular situation, Mr. Diedrich doesn't have a report yet. Mr. Bodziak is going to be testifying in, I believe it's Miami on Monday, and then he has several other commitments, so he hasn't written any additional reports. However, I will say, just as a little hint that I don't think we're obligated to give, that if counsel looks very, very carefully at the discovery materials, they will find what obviously Dr. Lee found, because Dr. Lee said that he disagreed with the report of Mr. Bodziak. So this is a subject about which there already is some materials that the defense has and may want to take a look at. Perhaps they should have taken a look at it a little bit earlier. But the point is that in terms of our discovery obligations, We have not told Mr. Bodziak either to create, at least I have not, told him to create or not to create a report. I simply asked him to try to look at some of the materials and photographs we sent, and the same thing is true with Mr. Diedrich, and they will do whatever they normally do. And I do not know how the defense can now argue that we are entitled to create something that does not exist when they have always taken the position that that is not required under 1054.
As to Diedrich and Bodziak, what kind of notes have you produced with regards to this latest testing?
There is no testing.
I mean, as to any of their activities in response to Dr. Lee's testimony, any notes?
No, Your Honor, the items that we sent, I believe, arrived, or Mr. Diedrich opened the box that contains the test impressions on either Wednesday or Thursday. And then there's also some photographs that we sent to Mr. Bodziak, which he looked at and opened the box the first time yesterday. So this is all happening very rapidly, and to my knowledge have not generated any notes other than that which Mr. Bodziak had previously generated prior to his testimony on the witness stand when he reviewed the items, including the jeans and the eyeglass envelope and paper.
All right. Some concerns. First of all, let me mark two pictures. P4.
Well, counsel, we're not going to hold a hearing right now to see whether or not this is a destructive or non-destructive test.
I understand that. I'm just passing up the photographs so the court can look at it to see whether my concern is made up or if it's evidenced by the photographs.
No, counsel, I share your concern about what may or may not be there as a result of having taken impressions from the Levites. The problem is we need the witness here, probably in a 402 hearing outside of the presence of the jury, to tell us what kind of tests these were.
Well, but my initial concern, first of all, and I want to make clear, is that they had no right to do this without notice. And that was wrong.
All right, counsel, we're here to find out
Secondly,
what materials you have.
I have nothing.
All right.
Secondly, it's very well for Mr. Goldberg to say that they're not going to ask him to write reports, but Mr. Hodgman and Mr. Yokelson, while he's off dealing with him, have told us, told you, told me on the record that Mr. Bodziak is going to be asked to fill out a report, and yes, they would get a report from him. So it seems to me that that is improper. It's one thing if it's not their normal practice to write a report. It's quite another thing to come in and tell us that they were going to get a report, and we're going to get it at the beginning of the week, and we get nothing.
And if you recollect, I told you I would be surprised that Mr. Bodziak did not produce a report.
That's right.
Yokelson and Mr. Hodgman have informed me, and I asked them about this previously, that that is not what they stated, and that they stated that if we got a report, they would turn that report over. They did not say that we were going to create a report, or they were going to ask Mr. Bodziak to create a report. And that is the representation that they made to me when I asked them this issue earlier this morning.
That all this goes to timing. And it seems to me that we're in no position, given these activities and given these tentative results and given the way they went about doing this without notice, so that we could monitor this. And they have everything we've done. They've had somebody there looking with a video camera, taking pictures. It's very upsetting that we're going to be ready to deal with this at all. I mean, right now, we don't have a date certain where we've seen Note 1, Report 1, Comparison or Examination 1 as to any of this.
All right.
We're putting everyone on notice that we're going to need an adjournment.
Maybe Mr. Scheck can put us on notice as to what statutory provision, case law, or order of this court says that we can't examine the evidence without notice to the defense. I am unaware of that. It's never it's unprecedented
I know
in
you're
our
unaware.
legal system.
I understand
It has
you're
never
unaware of
happened
that.
here before.
Wait.
But we had Griffin rulings in this.
All right. right, DeForest, you've turned over his notes. I'm still going over the notes to see if I find that there's any Brady material in there.
In addition to that, Your Honor, I'd like a proffer at this time as to DeForest. They've already told us they intend to use DeForest
Socks.
on the sock to rebut McDonald and Lee on the third surface from the ankle stain. Are there any other subjects?
Is that it? DeForest, Socks.
May I allow Mr. Hodgman to address the court, Your Honor? Could I be excused, please?
Mr. Hodgman, DeForest, Socks. And let me just add this, counsel, in my review of all of DeForest notes, there are some things that I need to ask the prosecution about with regards to Brady materials. So I'm going to, who is handling DeForest?
In terms of the actual testimony, that hasn't been decided yet, Your Honor. I've been talking with Mr. DeForest over the past several weeks.
For the purposes of the 1054.7 hearing and the Brady hearing,
I'm the one.
you're familiar with the materials?
Yes.
All right, then I'm going to direct you to be in my chambers on Monday at 8:30. I have some questions to ask you about some of the notes.
Very well.
Okay.
You know, Ed, Your Honor, just to advise court and counsel, whether Mr. DeForest testifies at all remains a question. I'll be speaking with him again tomorrow. And I should advise the court as well, with regard to Mr. Bodziak, with regard to Mr. Diedrich, and Mr. DeForest, as far as I've been advised, these individuals have schedules other than just responding to us. And you know, there sometimes are practical problems even making them available to us for moving the case ahead. With regard to Mr. DeForest, I'll be speaking with him tomorrow morning. At this time, I would anticipate his testimony would cover the socks. We've provided all sorts of discovery with regard to that. As to any additional areas, I think it's very questionable at this point in time.
Your Honor, the only concern I have about it being questionable is that we were told about 3 weeks ago that other items of evidence were also forwarded to Peter DeForest in New York, besides the socks. The envelope, for instance, the bindle from item 47. So, again, just to avoid the problem of ambush here or some last-minute change in this, they knew 3 weeks ago when these items were sent to him what his reaction was to these items, and if he was going to be providing expert testimony to refute defense experts. And it's difficult for me to accept that 3 weeks later, when the defense has rested, for all intents and purposes at least, although we haven't done it officially yet, that they don't know yet if he's going to be addressing these other issues for which he received the evidence to examine more than 3 weeks ago.
Well, it seems to me that they've had the opportunity to review his notes, and they've decided so far only to offer him as to the socks. If that changes, then we can take it up. I'll accept Mr. Hodgman's representation at this time. All right. As to, let's see, Leach was one of the fiber carpet people, correct? Carpet fiber people.
Yes, that's correct, Your Honor. Ms.
All right.
Clark is most conversant with that, but I'll substitute in place.
All right, but those the representation is that what they would testify to was turned over in the report that was provided during the People's Case in Chief.
And that's correct.
All right. Brad Popovich.
Notes and report have been turned over.
All right. Richard Rubin, are we going to get another report from Mr. Rubin?
No, the most recent
Or an interview or report?
interviews have been turned over. A taped interview and a report as to notes from a subsequent interview were turned over last week.
All right.
My understanding is that there was one picture that was sent back to him after that interview took place. I haven't heard anything about that.
And Mr. Blazier, you are correct. If I have just a moment. Your Honor, with regard to that last photo We don't have a written report. We understand that Mr. Rubin's opinion is that it is, the photo that was last sent was consistent, and we'll identify that for you, Mr. Blazier, in the material that, we have some more discovery material that you had asked us to prepare, and we'll turn that over as soon as we get a break.
We have other concerns about discovery that allows our ability to prepare. I don't know if you want to hear
Right.
those now or not.
Well, I mean, as soon as we have a break, I mean, where is the material?
It's right here. Mr. Armstrong has it.
Hand it over to Mr. Blazier.
I've been told the reports aren't here. Yes. You want to hear about whether we can be ready to do this on Monday? At some point, I need to address the court on that.
I just want to make sure that the reports with regards to these experts have been turned over. I'm just about to get to the end of the list.
Okay, I was just told that the report's not here. Unfortunately, down, yeah.
Well, why don't you take a look at it and see what you got? All right, as to Gary Sims, this is the RFLP. Mr. Hodgman, as to Gary Sims, this is as to the Bronco RFLP results.
And I'm not the most conversant in that. If Mr. Harmon may take the lecture.
Yes, we've turned it all over, and I'd like to clarify. Mr. Scheck complained at the beginning of one of those diatribes about just getting an autorad, and then he generalized that we're playing games. The reason he just got that one is because the date on it is September 5th, so it's a little bit, that's pretty fast, Your Honor, so I think he needs to be a little clearer and fairer or more objective in his complaints. So everything's been provided, or at least until I hear otherwise, I think everything's been provided.
The point, I would respect, since Mr. Harmon is here, I would respectfully request that before the end of the day that we argue this issue, because given the way this discovery is coming in, there's going to be a lot of work trying to catch up with what they're giving us in dribs and drabs, and if we could clarify this, that would help a lot.
All right.
Well, can I know personal commitments don't matter, but my last plane is at 7:30, so, and this was not on the agenda today, Your Honor. This was not on the agenda until 11:59 and a half when Mr. Neufeld, when everybody was leaving court, asked you if we could kind of talk about some of these things. So that was not on the agenda today.
Scope of rebuttal.
Pardon me. Mr. Sims was here yesterday. I know we've discussed this many times as this trial has progressed. Mr. Sims was here yesterday. If somebody really wants to hear why it took so long, there's only one way, and that's to have Mr. Sims here with all of his timesheets, and he's just not here. So I have no idea what the legal issue is, no matter how many times I hear about the complaints. So I don't think it is appropriate. I know this is something they've known about since July, by the way. So this is not a surprise. The other shoe dropped, then the other shoe dropped, then the other shoe dropped, then the other shoe dropped on September 5th. So this isn't a surprise that 4 shoes have dropped on this set of mixtures. But if they want to have a hearing, we can have a heck of a hearing. It's going to take a while, and I'd like Mr. Sims to fully explain everything, including all the time that Dr. Blake took of his during this. So that's the only problem. I know they really want to do this now, but we can discuss it superficially. But the only real way to get to the bottom of this is to put Mr. Sims up there and let him explain. That's going to take a long time, but
All right, when will Mr. Sims be available next week?
He'll be here Monday morning. He'll be here Sunday night. We could do it Sunday night if they want to find out about it before Monday morning. We'll be on a 7:30 plane down Sunday night.
If I might very briefly, I've reviewed the record on this. It was scheduled to be done today, not the day before, as soon as we got an opportunity to take up the scope of rebuttal arguments. And there's no need to call Mr. Sims on anything because the record is very clear. In March, this court granted them permission to combine the samples, 303, 304, 305 from the Bronco. Almost at that point, we began a discussion about the fact that immediate testing would be necessary in order to make sure that this evidence would be available for the end of the prosecution's case, whatever the results. And at that point, I began saying that this would be improper to raise it on the rebuttal case. And I commend the Court's attention to the transcript, page 27331. We discovered, and you did take testimony or statements from Mr. Sims on this. He wasn't quite sworn in, but he was sitting in the audience. You indicated that when they were given permission to combine the samples, it was the understanding, and you said at page 27331 of the transcript, it was all our understanding in March, that testing would begin immediately, if not sooner, quote unquote. That's what you said. Then it became apparent that initial quantitations were done, but no RFLP testing had begun on earnest. And then we had a discussion of this matter in May, when it was revealed that they hadn't done anything for a month and a half, except these initial quantitations. And at page 27332 of the transcript, you asked Mr. Sims questions about whether or not, how long it would take to finish the test. This is on May 12th. And he said a month and a half to 2 months. At which point, and I was arguing then that this was improper because they should have started it earlier, because it's something that could have been available for them at the end of the prosecution's case, and it was going to create an unfair situation if they were going to sandbag us with this issue on rebuttal. And the Court's statement and resolution of this issue at page 27340 was, well, I don't have to reach this now because, quote, we may have a preclusion by the passage of time. So the Court gave a very clear signal to the prosecution that, A, it was expected once the stains were all, permission was given to destroy all that evidence and combine them, that the testing should commence immediately, if not sooner. B, the record has already been established that they didn't do that for at least a month and a half, if not longer. C, in May, Mr. Sims, in response to the Court, indicated that it would take 1.5 to 2 months to do the test, so it still could have been done before the end of the prosecution's case, and it was not. They delayed even further. Now, the point is, if one goes back and looks at the transcript, Mr. Harmon and the prosecution has taken to the position since the beginning of this case that they had a right to do whatever testing they wanted, exactly when they wanted it, that they were under no obligation in terms of reasonable necessity or timeliness to do it in a fashion to get it done when the case started. And we went through that and we litigated that, and the Court gave them permission to do that. And he was taking the legal position then, well, we can do it whenever we want to. And the Court gave very clear signals at the time that permission was granted for them to combine all these samples, that it should be done, testing should commence on that immediately, if not sooner. Then the Court gave a very clear signal that preclusion by time would happen if they didn't get it done by the end of the direct case, because it's something that was available to them. I raised the issue that in terms of the law of rebuttal, that if, I think there's 3 factors here, would it be available to them on their case in chief if they proceeded reasonably and as the Court directed it would have been? Would there be prejudice if we were confronted with crucial evidence, a second factor, in an untimely fashion? No question about it. It made it very difficult to form the defense case, not knowing what the results from that would be and how. And then finally, a factor to consider in terms of the law of rebuttal, as indicated in our memorandum, would this unfairly highlight this evidence at the end of the case? Now, I think it's very clear, and I alerted the Court, and the Court alerted the prosecution to exactly what they were doing. This was planned. And so it seems to me that this issue is already framed by the record as it stands. Finally, and this is another factor I think we have to take into consideration from the reports we were just given, is that this is a complicated mixture. Dr. Weir, in a very baleful way in his report, indicates that he has done some analysis here that he gave us, but he hasn't even completed what he considers the best analysis. And I'm sure the Court won't forget the analysis and analysis and analysis over days that was being performed by Dr. Weir as he recalculated things while we waited for that to get done. And this RFLP mixture is something that we would definitely have to rebut with Dr. Shields on our case. So it seems to me that that is another factor in terms of the interest of justice considerations and the timing of this trial that should weigh heavily in this decision. But I don't think there's any question that they knew this day would come. And they were given fair warning, and the record is clear and complete on this point. And I would very much like to resolve it because we need to prepare in terms of all the other discovery that they're throwing on us at the last minute. And I can tell you, we don't like the idea of having delays, but we're going to be forced to do it in terms of this imprint evidence, in terms of this glove business, all of it.
Just a couple points. We look forward to Dr. Shields, who calls himself a hemigod, coming in. You recall him in that hearing out of the presence of the jury. So we anxiously await his appearance in this courtroom. I would like the court to remember that every time this has come up, Mr. Scheck has told you that all that evidence was consumed. And each time that he does that, I remind him that was not true then, it is not true now. And if someday I'd like him to be held accountable for continuing to tell you things that simply don't come close to the reality. I have my own notes compiled, a 10-page chronology beginning March 9th through August 3rd that I would like Mr. Sims to recount to you, because once again, it bears no relationship to Mr. Scheck's perception of what really happened through the course of the testing in this case. And for example, the defense knew before we rested what the results of the first probe were. They knew that. So to say that they never knew that and couldn't formulate their defense, they knew what the PCR results showed. So they knew where the other shoe was going, and the other shoe was going as long as we could keep testing it. All I've asked you for is an opportunity. I'm not here every day, but nobody has told me that this was scheduled for today except Mr. Scheck, and I'm not aware that it was. Mr. Sims was here yesterday, prepared to testify in the case in rebuttal. So I want an opportunity to convince you that once again, Mr. Scheck has not fully informed the court that contrary to popular belief, there are people who have other things to do in their professional and personal lives. There are deaths in the family, as you recall, a long period of time when Mr. Sims was here in this lovely city, waiting to testify, preparing to testify. So that's all. I want just a fair chance to convince you that there's not any factual merit to what Mr. Scheck has told you, and there's no legal merit to it. I mean, that's one thing we've never come to grips with, that there's no legal merit to it. But I think you can easily resolve this on a factual level, and that's all I want a chance to do, is convince you with Mr. Sims here.
All right. I agree at this point that I need a factual explanation as to what testing was done, what the scheduling was. I am concerned, however, about that 6-week delay between the time that the issue was presented to the court to allow the combination of those samples and before the actual commencement of the testing. I am concerned about that.
Absolutely, and we intend to address that with a day-by-day account.
All right. And he'll be available Monday?
Yes, Your Honor.
All right. Next issue. Sure.
Just for my own scheduling purposes, that's a hearing.
No, he's just...
We're not going to start with him. We're not starting with, you would have a hearing about whether or not it can happen, and then there'd be another day that he'd come back and testify to it if we lose.
Well, can we do that? I mean, if you allow him to testify, he's here, but we would hope you would allow him to testify forthwith. That's a
But what I'm contemplating right now, Mr. Harmon, frankly, is, as I indicated to counsel, my concern is... All right, as I've indicated to counsel, my concern is getting this case concluded. So any of these special hearings are going to be days and times that aren't normally scheduled to be with the jury. So my guess is that we'll conduct this hearing Monday at 5 o'clock.
And
Because
hopefully if you...
I assume that despite the fact that people say these photographers are only going to take 5 minutes apiece, I've never seen a 5-minute witness in this case, so.
Just so the record's clear, Mr. Clark is making Mr. Popovich available to me tomorrow for a conference call. So I'm going to be spending my time with Mr. Popovich. I'm not doing one thing about Mr. Sims until we resolve this issue. And if we do lose it, I'm not ready to cross-examine him right afterwards. I just want to make that clear. Okay.
Is it okay if I don't do anything then either? Or can we both not do anything?
Have a nice day, Mr. Harmon.
Thanks, Judge.
You're welcome. All right, Mr. Blazier, as to glove issues.
After the discovery?
Yes.
Last week, I think on Thursday, you ordered that the prosecution provide us with equal quality photographs that they intended to use. And this might help to explain what Mr. Rubin is doing. His testimony is to the effect that he's looked at some pictures and Mr. Simpson is wearing some gloves at some football games in the winter, and he says, look like Garris isotoner to me. Now, I don't know whether that's the proper subject for expert testimony or not, somebody looking at a picture and saying it looks like something. He's not going to say it's the gloves in evidence. He can't say that. He acknowledges that. We didn't get those pictures. Obviously, for me to show pictures to other people who might know about gloves, I've got to have the same pictures of the same quality, the same size gloves, whatever, so that I can have experts look at them and tell me, what do you think? I also might want to make my own pictures of gloves that we have that look very much like these gloves and do them in the same size, the same resolution, to test Mr. Rubin's ability to recognize different kinds of gloves. I don't know. The point is, I got 17 pictures at 2 o'clock. I've been handed another 27. Very nice pictures. I feel like it's Christmas. They're wonderful pictures. But what am I supposed to do in the 5:30 on Friday afternoon when I'm supposed to cross-examine 10 people on Monday? I've been asking them every day, can you give me an idea which of these pictures you're going to use and who you're going to call? Ask Mr. Yokelson almost every day, and he's very pleasant to me and shrugs his shoulders, says, I don't know, I can't tell you. Ask Mr. Faircloth every day. I don't know, can't tell you. Now I'm told that they have 11 people coming in on Monday, most of whom are from different parts of the country, and I have to assume that they made some decision before 2 o'clock this afternoon to bring people in from all over the country to put on all of these pictures, many of which, by the way, are pictures of Mr. Simpson wearing black gloves and not brown gloves. Nonetheless, I can't be ready to cross-examine 10 people on evidence that I just got this afternoon. This is a weekend. We've been in touch with glove companies. I've got 30 pages of lists of glove manufacturers all over the world, some of which we've already contacted. I've got gloves coming from Italy. This is the weekend. I can't prepare for this on Monday. This is ridiculous. This is not fair. Forget the beyond the scope argument. This is just not fair. And we're not ready to do this on Monday. We'll certainly have objections to cumulative. A lot of the pictures are just duplicative, so we may be able to weed out a lot of these people that way. But I'm not even ready to argue that until Monday. If they want to spend the taxpayers' funds to bring all these people in, we'll argue that Monday. But it's not reasonable to expect that we can be ready on this kind of testimony, getting this stuff now, on Monday.
Mr. Hodgman, when were these photographs available?
Your Honor, most of these photographs were available before today, and we provided the best available copy that we had to the defense before today. I don't have a list before me with all the dates, but as Mr. Blazier well knows, we've been providing for well over a week either laser prints, color laser prints, or the like. As we indicated to the court and counsel, we did not have negatives ourselves. We had to take what was sent to us by various photographers. We had to go back and implore, ask, and otherwise attempt to obtain negatives so that we could comply with what Mr. Blazier asked. That is that they obtain a like quality photograph of something we intended to present. The vast majority of those negatives came in either yesterday and actually the vast bulk of those came in this morning. We cleared our photo lab and pushed out those photos that Mr. Blazier received today. There was no delay in turnaround. They got them just about as soon as they came out of the developing tank, and we provided better quality material than we had ourselves until yesterday and today. So there was absolutely no delay in getting the negative quality prints to the defense.
The court needs to be aware that I've been watching the reports as they've dribbled in this week in terms of where these things came from. And every report that talks about when they got the picture puts the date at before they rested their case. These aren't things that just came in today in terms of them knowing about them. There are several reports that came in this week that don't have dates in them. The date that they received the picture has been conspicuously left out. But the ones where they put the date down, it's all before they rested their case. This is new stuff. We've been asking for this for a long time, and now we get it Friday afternoon, 5:30.
And for well over a week, they've had prints, the same thing that we have had, Your Honor.
All right, do I have a scope problem here if these matters were available to you prior to the resting of your case?
I was just hesitating because we did file a brief in response to the defense objection on the scope argument that I'm prepared to handle.
And I'll defer to Ms. Lewis on that if the court wants to argue that now. But as to the scope problem, I'll tell you just as a brief matter of fact, most of the glove material came in after we rested. I think there was 2 different submissions that I can recall, and one of those we're not even seeking to introduce. Be my guess.
I was just handed a brief. Was this just filed?
We filed it early this afternoon,
Okay.
earlier this afternoon.
Well, obviously, I'm not prepared to respond to that, but
All right, Ms. Lewis, does this brief deal specifically with the gloves?
Yes, it
Dates,
does.
times?
In terms of the scope argument, Your Honor, there is case law supporting, it does
No.
not matter.
No. Does your brief specifically address the glove issue? Yes or no?
In a broad sense, yes, it does not detail the dates in which everything was received.
Okay. All right, then I guess we probably ought to take that up first thing Monday morning. Scope of the glove presentation. But I'm going to need dates, times, declaration as to when those things were.
Your Honor, please don't get offended before you read the case law cited in my brief, because it does not matter. The court may agree with people's position that under much of the case law, it's,
Well, since you just filed it, and obviously I've been busy all afternoon,
I can appreciate that.
haven't seen it, haven't read it yet. All right?
the court's aware that we made certain tactical decisions on the defense based on
No,
them
I'm-
not doing this before.
Thoroughly aware of that, counsel. There are several tactical decisions that have been interesting. All right. Experts, gloves, what else do we need to resolve now, since we're not resolving much of anything?
What I would suggest, Your Honor, if it's acceptable to the court, is in light of the fact that I think Mr. Blazier has already represented that he will not be prepared to go forward on the gloves, even if you ruled that it wasn't beyond the scope of rebuttal on Monday, and we're not prepared to go forward with those experts right away for a variety of reasons, which we've already laid out to the court, I would ask that the prosecution be instructed to be ready with those civilian witnesses who we discussed the other day. We got notice of several days in advance, if you recall, the witnesses pertaining to Mr. Heitscher. There was a flight attendant from American Airlines. The only other point I would make about the witnesses pertaining to Mr. Heitscher, even though the civilian witnesses, and we would be ready to deal with them, as soon as prosecution starts the rebuttal case, I would point out to the court that Mr. Darden represented that the Heitscher witnesses are not rebutting Heitscher's testimony, but are simply trying to corroborate it. And if that's really what Mr. Darden means when he says that, then clearly that would not be appropriate for rebuttal testimony.
Well, that'll be part of our scope of rebuttal discussion, I suspect.
And I didn't say corroborate. I
What
said
I would
actress.
What I would also ask, Your Honor, is that that the people be instructed to prepare by Monday, because we're going to be dealing with scope of rebuttal, any points and authorities they have on those other issues that you highlighted, that where bells went off, I think, like the Dutton issue, that should be filed by Monday morning so we can respond to it in a timely fashion if we're going to finish this rebuttal case in 5 days. That they also have the points and authorities by Monday morning on the Bronco Fiber revisit that they're asking the court to do. And they also have the points and authorities by Monday morning on June 17th witnesses. Because if we're going to deal with the scope of rebuttal, we need to have those authorities right away on Monday so that can be resolved. And I'm not trying to I think it's reasonable, Your Honor, because there's only so many of us, and if there's 59 witnesses, we have to figure out what the heck to do first. And until you somehow circumscribe some of that.
There's only so many of you?
There are.
There's probably 20 of you on each side, and there's only one of me who has to read all this stuff.
I understand that, Your Honor, and that's definitely a disability, but it would certainly make it easier for you to get started on that if they got the points and authorities and those issues in Monday morning, so we could at least know where we're heading.
All right. Well, I'm going to, as I mentioned to both sides, I don't tell either side how they're going to put their case on, what order they're going to call people, but it would probably be a good idea that you have people available on call in other topics or other areas in case the worst happens. I don't know. I haven't heard the scope argument yet, but you should be prepared to present some meaningful testimony to the jury on Monday.
We will be prepared. I think
Good.
we can accommodate counsel's request with regard to briefs on the fiber.
No, actually, when the court indicated it wanted the record sides and the fiber, we don't have the transcripts yet for the record sides on Kathleen Bell's testimony, for example, with regard to the type of
Use the real time.
automobile detective permit.
All right, just I'm going to encourage you to be ready and have witnesses on call to go forward with other areas of your case in case we run into problems regarding gloves.
For the record, Your Honor, and I have some notes here, on August the 30th, following our discussion with Mr. Hodgman about who we were going to be hearing from in rebuttal, he said DeForest maybe, he wasn't sure. He said there was some glove evidence depending on an event to occur on August 31st. He named David Atkins, he named Miss Anders, Miss Barrett, Mr. Fields, Mr. Boziak, and Miss DeTeresa. He wasn't sure about DNA, he wasn't sure about EDTA. Those were the only names we were given. Later, Popovich came up until this list we got today. And that just is intended to highlight the exasperation that we feel at this point, given these abundance of names and the order that is now being presented, which we were not otherwise advised of before today.
This is rebuttal. Mr. Gordon has informed us that he'll have a brief ready on Dr. Dutton first thing Monday morning. As far as the June 17 witnesses are concerned, they would be toward the end of rebuttal if the court were to permit us to put that evidence on. So counsel will have that additional time, and we'll try and get the brief ready on Monday for that as well. And we'll do everything we can to move it along. We'll be ready Monday morning.
All right. Okay.
What's okay?
Okay, they said they're gonna file a bunch of briefs on Monday. We'll have our scope hearing first thing Monday morning. I'll do my 1054.7 Brady in camera hearing with Mr. Hodgman at 8:30. 9 o'clock we'll have our scope hearing, and hopefully by 10 o'clock we'll be putting something in front of the jury. All right, and at 5 o'clock we'll have our Sims hearing. All right. I'm tired. It's the end of the day.
I just
Yes.
want to remind the court, I don't know if the court's even aware, we got a started with a pitches motion, which I assume the court that it's noticed for Monday and for shortening time on that 30 manner, I believe. So,
Have we heard from the city attorney's office regarding the request for an order shortening time?
We had faxed them today, Your Honor, a copy of the motion we told Ms. House yesterday at becoming. She asked that the production be delayed. We asked that the hearing itself be at 9, the production of any at noon.
Okay.
In that regard, actually, if Mr. Hodgman could track the cases
involving Detective Purdy and Detective Furman, and we could see if we could link those up as being the same incidents, then I think we would be well on our way factually to getting a more coherent handle on where that's all going.
All right.
One final point. I'm reminded that in view of the Court of Appeals ruling today, we are this weekend reevaluating the wisdom of our choosing to rest on Monday and whether it's appropriate to take other appropriate steps.
I can't imagine why they're complaining about discovery and rebuttal then when they, even they themselves say they aren't ready to rest yet, Judge.
Because we want to end the case.
All right. I have one other matter that does not involve the parties. We had a violation of the court's order this morning regarding still photography in the courtroom, and I've determined to terminate still photography in the courtroom, so I'm taking Ms. Sager, that's why you're here? All right. Then if it's of no further interest to the real parties in interest, I'll excuse them at this time.
Mr. Saxon is also here.
All right.
If the court would hear argument about the presented, have Mr. Saxon address the court before
Let me allow counsel to clear. I'm sorry? Thank you. I'm glad somebody appreciates that. All right, thank you, Madam Reporter. Ms. Sager.
Yes, Your Honor. Mr. Saxon is here with me, who is the still photographer who was running the pool this morning. It's my understanding that what has occurred is, again, simply what I think was a misunderstanding of an incident that's occurred before the court some time ago when a still photographer took a picture during a break, which the court has ordered that no pictures be taken except when the court is in session. But during that hearing, there was a discussion of the need to take a test photo on certain occasions to make sure that the still camera was working. And it was the impression that...
Test photo of the seal.
Yes, Your Honor. At that time, the court made the comment when he was explaining that he focused on people because that's what normally is being taken pictures of. The court made the comment, I believe, something to the effect of, well, that's what the seal is for. And the impression given to the still photographer and to the pool, my understanding...
Ms. Sager, let me tell you what causes me great concern and why I'm going to terminate the still photography coverage, is because when this happened, I heard the camera go off myself this morning when I was here at 8:30, and I was here out on the bench clearing items, getting set up, getting my computers running, making my notes, and I hear the camera go off, and I look and I see it directed towards me. And that's a direct violation of my order.
Well, Your Honor, I believe the court has reviewed the footage, the one still camera shot that was taken this morning. It was not a picture
No, Ms. Sager,
of
I
the
haven't had
court.
time. It would be a tremendous waste of my law clerk's time to send them down the Fox photo to get 1-hour photos. I haven't had the time to do that. I've been busy with other matters.
I appreciate that, Your Honor, and certainly Mr. Saxon or a member of the still photography pool is happy to take that task in hand. The picture, as I understand it, was not of the court. It was simply focusing on the far wall because the position of the still camera, given the screen that is between the camera and the seal, makes it
And
difficult
I
to
just happen to
focus.
be in between those two things. Isn't that unusual?
Well, Your Honor, if a picture was taken of the court, I could understand you being upset. And there was no intention to violate or
No,
flaunt
I'm
the
not
court's
upset
order.
about people taking my picture. I'm upset about the fact that it's a violation of my court order.
The picture, as I understand it, Your Honor, was simply focusing on the wall so that a focused shot could be taken, which can't be done of the seal with the still camera the way it can of the video camera. And so the focus was on the far wall because if you can't get something in focus, you can't tell whether the camera's working or not. And that was what the camera was pointing at, and the camera was moving around the way it does without a picture being taken to make sure that everything's working. Because unlike the video camera, my understanding is the still camera has to be, taken down or broken apart or broken down, whatever the terminology is, every night. And so they have to make sure in the morning that it is working when they put it back together. And that's the reason a test photo is taken. And Mr. Saxon can explain precisely the mechanism involved in having to do that. But it was not an intent to take a picture of anyone in the courtroom, and no picture, as I understand it, of anyone in the courtroom was taken, but simply a focus on the far wall. And to the extent that was in disregard of what the court's intention was when it referred to taking a picture of the seal, then I know Mr. Saxon is deeply apologetic, as are all the members of the pool. But the intent was to try to follow what the court had implied, or at least was understood, the last time this issue came up, which was don't take any pictures of anyone in the courtroom. You're supposed to do your test shot if you need to on a stationary object, the seal, which is what the video camera focuses on when the court is not in session, not taking any pictures of anything or anyone going on in the courtroom. And it's my understanding that that's all Mr. Saxon was trying to do. And he is here and is happy to address the court and has written out an explanation that he's happy to have me submit to the court and would ask for the court's leniency and not punishing.
Problem is, we've been through this once before, haven't we?
We have, Your Honor, but as I explained, the
And
upshot of that hearing...
I thought I was crystal clear.
Well, I appreciate that Your Honor may have thought that, and again, we apologize if there was a misunderstanding, but that's all it was. And had a picture been taken of an individual in the courtroom, then that would seem to be more in line with a punishment that would be appropriate to a flaunting of the court's order. But here, what was done was an effort to try to satisfy the court's concerns that no pictures of people be taken when the court was not in session.
Well, all that had to be done is notifying Ms. Hazlett that there's a technical need to do something, and that a regularly scheduled time that a photograph would be taken of some inanimate object in the courtroom. That was not done.
I understand that, Your Honor, and that, as I said, Mr. Saxon and the pool are apologetic for that,
So when
but
I'm
thought they
sitting
were
here
trying to...
get prepared for the morning, and I hear the camera going off, and I look and I see it directed in my direction, I'm concerned.
I can appreciate why the court would be concerned. And that's why Mr. Saxon has wanted to offer an explanation of what happened to make it crystal clear to the court that no pictures of Your Honor were taken or of anyone in the courtroom, nor was there ever any intent to do that. And to the extent that there was a misunderstanding about the intent of the court's order when this last arose, that's all it was. They simply thought that the purpose of the discussion last time was to make it clear to focus on the inanimate object and take a picture.
Mr. Saxon, can you see the clock with your camera?
Yes, I can, Your Honor.
Next time, take a picture of the clock.
Yes, sir.
All right? Fine is $250.
Yes, sir.
Thank you, Your Honor.
I apologize, Your Honor.
Accepted.
Please clear the court.